Test, test.
I think I got it.
You're live. You're live.
Good morning to everyone. This is the official Oil Conservation Commission meeting that is slated for today. I am Gerasimos Rosados. I am the acting director for the Oil Conservation Division. I go by Jerry, makes it easier for everybody. And as I mentioned, this is our Oil Conservation Commission meeting that we have normally planned. Plus, we also have a hearing that we're going to be doing. So before we start, though, I wanted to start with a roll call. As I said, I'm Gerasimos Rosados. I am the acting chair for the commission, and I'll move to the commissioner to my right.
Morning, everyone. I'm Greg Blue. I'm the Assistant Commissioner for Mineral Resources at the New Mexico State Land Office. I'm the designee of the Land Office, and I will be stepping aside today for case 24123. Unfortunately, my duties up at the legislature preclude me from being here most of this week and next. So Balin Lampkin will be stepping in for just that case. Balin, you want to give us a wave and people can see you? Yeah, he'll introduce himself later. He's a petroleum engineer at the Land Office. Thank you.
I'm Dr. William Ampoma, Professor at New Mexico Tech, a designee of the Energy Secretary. Thank you.
Excellent. So that is the commission. So before we start, we always want to do the approval of our past agendas or the current agendas. So I'm asking for an approval for the February 20th through 28th, 2025 agenda.
I so move.
I second.
All in favor?
Aye.
Aye.
Aye. Okay. So our agenda has been approved. We also need to approve the meeting minutes for the January 16th and 17th and the February 3rd, 2025 meetings. If we could get a motion for that.
I so move.
I second.
May I get a roll call? All in favor?
Aye.
Aye.
Aye. Okay. So that has been approved. We're going to move now on to our pending cases. Our first case is case number 23580, application of Wild Earth Guardians to amend the Commission's rules to address PFAS, amendments to 19.15.2, 19.15.7, 19.15.4, 19.15.16, and 19.15.25 in the New Mexico Administrative Code. This is a status conference to schedule the date for the commission's deliberations. Are all parties present for this? Yay, nay, people?
Good morning, Mr. Chair. Jesse Tremaine for the Oil Conservation Division.
Excellent. Thank you.
Jesse, what's your last name?
Tremaine.
Tremaine.
Good morning, Commissioner Rosados. Adam Rankin appearing on behalf of the New Mexico Oil and Gas Association.
Excellent. And anybody from Wild Earth Art Guardians? Maybe on the platform? No. Okay, well. We can go ahead.
Matthias Sayre on behalf of EOG.
Okay, excellent. Thank you, Mr. Sayre. Well, we'll still proceed and we'll go from there. As I stated, we have a status conference scheduled for the commission's deliberations. We did come up with a date for the deliberations. Sheila, is Miss Orth on the platform?
I don't see her on the platform.
Okay. So the date that was submitted was either March the 11th or March the 12th, correct, Sheila?
Yes, that's the date we were working with.
Okay. Does that work for everybody? Mr. Rankin, we'll start with you.
I believe so. Let me just double check my calendar. Thank you very much. One moment. You said it was March 11th or March 12th?
Correct.
Okay. That should work, Mr. Chair. Thank you.
Okay, thank you, Mr. Tremaine.
No conflicts. We are available.
Excellent. Thank you, Mr. Sayer. Okay, so no conflicts for Mr. Sayer. And we don't know about Wild Earth Guardians. So we're going to set it for March the 11th. If they have an issue, they could definitely let the commission know and we can tackle it at that time. So March 11th is the date that we will set for that one. Sheila, if you could note that down for us, please. I do know that those were dates that Miss Orth, they did work with Miss Orth, so she is good with that as well. So we'll be able to go that route. Any other questions or comments on this particular case?
Sorry, just kidding.
Excellent. We'll move on to our next case, case number 24683, application of Western Environmental Law Center, Citizens Caring for the Future, Conservation Voters of New Mexico, Education Fund, Dene Care, Earthworks, Navia, New Mexico, Interfaith Power and Light, San Juan Citizens Alliance, and Sierra Club to amend 19.15.2, 19.15.5, 19.15.8, 19.15.9, and 19.15.25 in the New Mexico Administrative Code. This is set for a status conference. Are all parties present for that? We'll start with Western Environmental Law Center.
Yeah, Kyle Giselle for Western Environmental Law Center and the other co-petitioners.
Excellent. Thank you.
Good morning, Mr. Chair, members of the commission. Michael Felderworth, the Santa Fe office of Holland and Hart for OCC USA.
Okay, excellent.
Good morning, Miguel Suaza with Beatty and Wozniak, appearing on behalf of the New Mexico Oil and Gas Association.
Thank you, Mr. Swaza.
Jesse Tremaine on behalf of the Oil Conservation Division.
Excellent. Thank you, Mr. Tremaine. Anybody on the platform?
Good morning, Commission. This is Ann Tripp on behalf of Hinkle Shaner, appearing for Intervenors Independent Petroleum Association of New Mexico.
Excellent. And you said TRIP, correct, Ms. Tripp? T-R-I-P-P?
TRIPP. Yes, sir.
Okay, excellent. Thank you. Anybody else? Okay, we'll start with Western Environmental Law Center or anybody who would like to make a comment.
Yeah, thank you, Commission. So our petition was filed in June of 2020, June 24th of 2024. The petition was granted by the Commission on July 18th, and a hearing date was set for April, and that was done in September of 23rd of 2024. We had set up meetings in October with all of the parties to work through the petition as it had been filed. The Oil Conservation Division was also diligently working through their red line version of the filed petition. We were anticipating that OCD's red line would happen by the end of the year due to, I think, workflow issues and a number of constraints on OCD's time. We did not get that red line until February 12th. Mr. Tremaine of OCD also did notify the commission on January 28th that we would need to continue and reschedule the hearing dates that were set in April. So we do have that red line. We are I think all the parties at this point are working through that red line. There is a need, I think, for us to come back together and confer and see if we can come to some agreement on different dates for the hearing.
Okay, so we don't have any dates suggested as of now.
Not as of now.
Okay. Mr. Tremaine?
Mr. Chair, good morning. Thank you. There have been a number of discussions between the parties in advance of our sharing of the revised red line. However, it's going to take some time for everyone to figure out the different conflicts, et cetera, and propose some dates to the commission. I think that there are some elements to OCD's red line that will require a different examination of evidence at the hearing. And so we have moved the needle a little bit in terms of what witnesses and what experts might need to be available for all the parties, and absolutely respect that they will need some additional time. So with the 8 days since we've circulated the petition, we haven't reached a particular proposed date. But what I would suggest to the commission is that we can communicate between the parties over the next week or two and submit revised proposed scheduling order for the commission's review.
Okay, Mr. Swaza.
Sure. Good morning, Mr. Chair and Commissioners. I concur with the parties that, we need to get together and really assess OCD's proposed changes. I think, since the trade association is made up of members, we just got this last Wednesday. We haven't even had the chance to confer as an industry about what these changes mean and what types of witnesses we're going to require, whether or not this warrants the association proposing their own red lines and so on and so forth. So I think that because the new changes by OCD were received so recently, we are going to need additional time. This is essentially a reset to a degree of the initial proceedings. And so we're not even scheduled to meet as an industry until next week. After that point, they would need to confer amongst themselves, provide the attorney's feedback, probably have another follow-up meeting. So I think realistically, we're not going to be in a position to, look at dates, that make sense for us for, I would say, at least 30 to 60 days, probably more closer to 30.
Okay, thank you, Mr. Feldowert.
I concur. I think we've kind of had a reset here. And it's going to take some time to get the parties together and then determine what evidence is going to be required with the changes that have been posed and what additional changes may be needed by my client or other clients. So I think we're in a position where it's going to take a little time to get this set up again for a hearing.
Okay, thank you. Ms. Tripp, did you have anything you wanted to add?
Commissioner, thank you. IPNM is in a very similar situation to NMOGA in the sense that we are a member organization, over 350, and we've not yet set a time to meet to discuss the changes and whether a proposed red line would be necessary. So concurring with what everyone has said here today, that the parties need to get together and that the timeline for that is likely in the next 30 days or so.
Okay, excellent. So if we need probably another 30 days, Mr. Tremaine, go ahead.
Mr. Chair, hearing that the parties will require, I understand, but somewhat longer than I had anticipated, my suggestion would be to set this for a status conference at the next meeting.
And that was what I was just going to say. You beat me to it.
I just wanted to be on the record as changing my position. Thank you.
Okay, excellent. So why don't we set this for a status conference at the next OCC meeting, the March meeting. Sheila, what date is the March meeting?
March 20th.
March 20th. So we'll set it as a status conference for March 20th. Hopefully you all will have been able to get together and come to some consensus for days. Mr. Rubin, I see you. Did you need something?
Oh, no.
Oh, okay. Go ahead, Commissioner Bloom.
Mr. Chair, I can't remember if this is something we set during your tenure, but we did set some tentative dates and held space on our calendar the weeks of the 14th and the 21st. I'm going to assume that those are freed up now and open up my schedule for other meetings.
Joy for you, huh?
Yeah.
I believe that that's the consensus. We are opening up the April. So April now is open. Those dates will be released. We will meet back again in March for this topic as a conference, status conference. And as I mentioned, hopefully you all will have come to some conclusions and some decisions, and we can probably set a date, March 20th. If you need more time, definitely we can discuss it at that point, but maybe we can set that. Just remember, everybody, we're going into the summertime here. So schedules will get tighter with summertime. So please be cognizant of that as we're scheduling that out. Excellent. Any other points or questions, comments for this particular case? Great. We'll see you all on March the 20th.
Thank you.
Thank you.
Mr. Chair.
We're going to be moving into our consolidated cases, but before we do that, let's take a few minutes so the parties can have time to change tables and everything. So let's take a 10-minute break. Okay,
You did it this morning?
let's start up again.
Oh, that's why.
If I could get everybody's attention.
It's all over. Start doing it again. Exercising, that is.
We will start up with our next case. Our next case is the consolidated cases by Goodnight Midstream and Empire, New Mexico. The case numbers are, as I said, consolidated. So we have case numbers 24123, 23614 through 17, case number 23775, and case numbers 24018 through 24020 and 24025. This is a matter to be heard by the commission, its motions and opening statements today and tomorrow, and actual evidentiary hearing starting Monday, the 24th through the 28th. Are all parties present? I'm going to start to my right and move across the room. Mr. Rankin.
Good morning, Mr. Examiner, Commissioners. May it please the Commission, Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of Goodnight Midstream in these cases.
Excellent. Thank you.
Chris Moander, counsel appearing on behalf of the Oil Conservation Division.
Excellent. Thank you.
Good morning, Commissioners. Dana Hardy, appearing on behalf of Empire, New Mexico, LLC.
Excellent. Thank you.
Good morning, Sharon Shaheen, also appearing on behalf of Empire, New Mexico.
Excellent. Thank you. We'll move to the back table right behind Ms. Shaheen.
Good morning, Commissioners. Miguel Suazo with Beatty and Wozniak here, appearing on behalf of Pilot Water.
Excellent.
Members of the commission, Ernest L. Padilla for Empire, New Mexico, LLC.
Thank you, Mr. Padilla.
Matt Beck on behalf of Intervenors Rice Operating Company and Permian Line Service, LLC.
Thank you, Mr. Beck.
Mr. Chair, I neglected to introduce my colleague, Julia Brogy, also with Holland and Hart, who will be assisting me in these cases.
Excellent. Thank you, Ms. Brogy. As we stated that this is going to be motions and opening statements today, it is a matter to be heard in front of the commission. We do have a hearing officer with us, Mr. Rip Harwood. So I will transfer it over to Mr. Harwood to begin the proceedings. Mr. Harwood. Mr. Harwood, if you can click on your microphone, the right button. There you go.
Just going to ask what illuminates the green light. Okay, good. Good morning, everybody. And let me, I have a list of things here I want to go through, but first of all, I have a sheet here of motions that were filed, and I believe that all the pre-hearing motions have been resolved, but I'd like to hear from the parties if there's any disagreement, and I guess I'll start with you, Mr. Rankin.
Good morning, Mr. Harwood. My understanding at this time is that all the preliminary motions that have been filed in advance of the hearing have been addressed and disposed of. So there is nothing pending at this time, is my understanding, for decision.
Yes, sir.
Mr. Hearing Officer Chris Moander, OCD. My understanding is all the pre-hearing motions that had been filed that were pending have been resolved. However, OCD will likely be submitting a motion for reconsideration on an order that was entered yesterday, and I anticipate we'll be filing that by the close of business today. So that will be outstanding. I won't speak for the other parties, but I'm not anticipating that there will be any party response to that because it's very specific to a particular order. So that will be forthcoming. I'm not clear who will be addressing that, but I'll ensure that that's filed today.
Okay, Mr. Moander, I look forward to your outstanding motion.
Thank you,
Ms. Hardy,
sir.
Good morning, Hearing Examiner. From Empire's perspective, all of the outstanding motions have been resolved.
All right. And let's see, Ms. Shaheen.
Ms. Hardy speaking for Empire today.
Okay. Mr. Sorry, I'm sure by the end of next week, I'll know everybody's name. I know you, Mr. Beck. Go ahead.
All right. Yeah, same for Rice and Permian. We understand all the motions are decided.
Okay. And for Empire. Oh, I'm sorry. You already spoke for Empire. let's see. Okay, so there are three of you for Empire. All right, fair enough. All right, so.
Mr. Hearing Examiner, did you ask for pilot? Mr. Swazo with pilot.
Oh, I'm sorry, Mr. Swazo, didn't mean to overlook you.
No problem. Pilot considers the outstanding motions resolved as well.
All right, thank you very much. Okay, so while we were on the break, I spoke informally with Mr. Rankin because my understanding is that we have 5 days for this hearing, and in speaking with him, my further understanding is that we have approximately 22 witnesses to get through. So I don't know if the rest of you share Mr. Rankin's pessimism, but he's thinking that 5 days is probably not going to be enough for this hearing, which was news to me. It may not be news to the commission, but the reason I raise it is because one of the first things I like to go through is order of presentations and time allotments. My understanding, again, from a sidebar conversation with Mr. Rankin, is that you all have agreed on order of presentations, Empire to go first, Goodnight to go second, and then OCD to go third. Is that correct?
I believe so, Mr. Hearing Officer.
Mr. Hearing Officer, it was an order. That last paragraph there that was dated states the order that we had decided for the actual case. I forget the date of the order.
Okay, I'm not sure when this was dated, but I guess I should have read it more carefully. So that solves that issue. So that's the order of presentations. Let me hear from you, Empire, Ms. Hardy, or Ms. I'm sorry, I want to get the pronunciation correct. Shaheen? Let me hear from Empire. How long do you think that you'll need to present your case and your witnesses?
I think that, of course, it depends on the amount of cross-examination time and questions from the commission. But based on the number of witnesses, it seems that it would likely take several days, possibly the first week. But it depends on the time of cross, of course.
You know, I used to do a lot of jury trial work, and I had judges tell me, okay, we have a week for trial. You've got till Wednesday at noon, and then you turn it over to the other side. I'm assuming that that's not going to be the protocol here, and that the 5 days can stretch into 10 days, 12 days, whatever it takes. I guess the concern there, given the number of people involved, including the time constraints of all the parties and all the commission members, is that if we go more than 5 days, there may be some break between the first part of this quote unquote trial and the rest of the proceeding. It's very unlikely, I suspect, and the commission can tell me if I'm wrong, that we'll be able to reconvene the week following next week to continue this hearing immediately.
I think you're correct, Mr. Hearing Officer. I think that we're all going into this knowing that we're dedicating the 5 days next week. And then as of Friday of next week, we'll see where we're at. And then we're going to have to look at schedules. Okay. So we are definitely, I think the goal is to try to get it as soon as we possibly can to reconvene. But again, there's a large number of people that are involved. So schedules will definitely be of the utmost concern by next Friday.
Okay, so the downside of going beyond 5 days, obviously, is that there's going to be, this proceeding is going to end up being an extended hearing over a period of probably a month or more, would be my guess. Okay, so I don't think it makes any sense at this point then to even talk about time allotments. We will assume that on Monday, Empire will start with its first witnesses. We're going to have opening statements today from everyone, correct? So at least we'll get that out of the way.
I believe that's correct, Mr. Hearing Officer.
Any estimate on the length of time you all need for opening statements? I guess, is this the last item on the agenda, Mr. Rosados?
This is the last item on the agenda, and we are slated to potentially go into tomorrow if need be for opening statements. This is a very lengthy calendar. So today and tomorrow are slated for opening statements. Evidentiary hearing starts on Monday. So however long it takes once we start.
Well, I almost hate to hear that because it encourages people to go on and on. I'll just remind everybody that, opening statements are just to give everybody an overview of what they expect their witnesses to say and what they expect to prove. We don't need to hear the whole case since we're going to hear the whole case from the witnesses. So just bear that in mind. It would be nice if we don't have to go into tomorrow. In fact, if we have tomorrow, and I'm just floating this idea for everybody, since we only have 5 days for trial, is there any chance if we get through openings today that we can start the hearing on the merits with witnesses tomorrow?
Mr. Hearing Officer, I think, and I apologize, these were all issues we did kind of tackle. The witnesses are only going to be set starting Monday. Schedules for the witnesses were also kind of set with that. So we are kind of on a time crunch. I think all the parties, and correct me if I'm wrong, parties, everybody agreed, especially at the last meeting that we had, that we were going to be as expeditious as we possibly could be on this particular case. But I think everybody was aware that this was going to take more than the 5 days. I apologize for taking this from you, Mr. Hearing Officer, but I'll just start from one side of the room and move my way across. Is that how you understood it, Mr. Rankin?
Yes, Mr. Chair. And I think part of the problem with starting on Friday that we just discussed is that lots of people are traveling from lots of different places and having to go back on the weekend just didn't make sense. So we just decided to start on Monday.
Excellent. Mr. Moander?
Mr. Chair, that is OCD's understanding, and we have prepared under that understanding.
Okay. Ms. Hardy or Ms. Shaheen?
Yes, same for Empire Commission.
Okay. Mr. Swaza?
Same for pilot.
Okay. Mr. Beck?
Yes.
Okay. So we all have gone into this knowing that starting Monday witnesses and then however long it takes.
All right. Well, I didn't mean to open a can of worms, but time is of the essence in these things. So, all right. So the next thing on my list here, Goodnight had mentioned that its expert Larry Lake has limited availability at the end of the week, given the fact that Empire is going to take most of the week. Is that even still an issue?
Mr. Examiner, I think if Mr. Lake, if we're not able to get to our case by the end of the week, then he would just have to appear remotely. I think that probably be the situation for him.
So you'll be able to work around it?
I believe so.
Okay, fair enough. I don't know if this is something that happens here or not, or whether it even applies in these cases. It's on my list, in all the civil trials I did, I routinely excluded non-expert witnesses from being present to overhear the testimony of other witnesses. I don't know if in these cases there are any witnesses other than experts. I'd like to hear from the parties if the rule of exclusion is even an issue here. Mr. Rankin.
Mr. Hearing Officer, I don't believe so. I appreciate you raising the question, but I believe in every instance, all the experts, all the witnesses in this case, our consolidated cases are all experts across various different overlapping fields.
Can you speak up a little?
Sure. No, I believe that the rule of exclusion wouldn't apply here. In every case, all the witnesses will be testifying are experts in various overlapping fields.
Okay.
Mr. Hearing Officer, OCD would agree. I don't think I've seen a witness in this case that would be considered a lay witness. under the rules of evidence. So I don't think the exclusionary rule matters at this point.
Okay, I thought maybe there were principals for Empire or Goodnight that might be testifying. No, Ms. Hardy?
Mr. Examiner, thank you. I agree that the witnesses are experts and the exclusionary rule wouldn't apply. And with respect to the presentation, I just wanted to go back for a minute and mention that the parties have agreed to spend approximately 15 minutes with each expert on direct because they have filed direct and rebuttal testimony in writing. So we are working to expedite the hearing in that regard. So I think the amount of time that each witness will take will depend really on cross-examination and questions from the commission. So it's possible we could get through Empire's witnesses more quickly, just depending on how that goes.
Well, I appreciate that. If that weren't the case, we'd be looking at a month-long trial, right?
Yes,
Okay.
I agree.
Anyone else on this rule of exclusion issue? If I hear nothing, then I'll assume everybody's in agreement. Okay. And of course, it doesn't apply to expert witnesses. You all understand that because experts can change their opinions all the way through trial based on what they hear. So they're welcome to sit in and listen if the parties want to pay for that. Okay, so the other thing is I'm assuming that this hearing will go from 9 to 5 every day next week, or does the commission break earlier?
I think we were slated for 9 to 5.
9 to 5, and then we'll have a lunch break.
Correct.
And I'm assuming we'll have a mid-morning and mid-afternoon break.
Right.
Okay, fair enough. Let's see. So this is just for everybody's. This is mainly for my benefit, I should say, and I'm sure that the commission members are more familiar than I am, but with abbreviations and acronyms. When you guys present your cases, if you could do your best to at least explain that stuff the first time it comes up so that, technical ignoramuses like myself can start picking up the jargon. Okay, it's prevalent in government work in general, and there's a whole set of acronyms that apply in the oil and gas field. So these guys may know it, but it would help me if you guys can try and remember that. Okay, the last thing, I just want to make it clear, based on the research that's been done, your substantive presentations in this case are to the commission. They're not to me. Given Mr. Rankin's comprehensive research results, my only role here basically is to resolve procedural issues and, to at least make provisional rulings on evidentiary issues subject to, the commission's review and possible overruling of my views on the subject. As a hearing officer for other state agencies and most of the hearings for the city of Albuquerque, I'm used to being the complete decision maker. So my role here is a bit of an oddity for me. I feel like I'm half a master of ceremonies and half law clerk. So it doesn't really matter to me. In this day and age of my semi-retirement, I basically work for boat parts. I spend half the year in Maine, and my boat is a typical jealous mistress. It doesn't care what I do so long as I keep feeding it. Anyway, so that's what I will be doing. I will not be making any substantive recommendations to the commission. And at the end of this, whenever that may be, it's a quorum of the commission that will decide all substantive issues raised at this hearing. All right. Okay. Anything further from the commission? Mr. Rubin, anything you'd like to add?
Just that everyone else should silence their cell phones.
Okay. Excuse me. By the way, I caught a cold coming back from Miami last week, but I want you to know, doctor, that I don't think I know it's not COVID and I don't think it's still contagious. So, but I apologize for that. So, does anybody need a quick break before we go right into openings? Or are you all prepared at this point to begin with your opening statements? All right, then let's hear from whoever for Empire will be making their opening remarks.
Thank you, Mr. Examiner, Commissioners, Dana Hardy on behalf of Empire. And I am going to try to share my screen here. And hopefully this will work. Okay. So to give you a brief factual background on these matters, these cases involve Goodnight's continuing and proposed additional injection of foreign and incompatible produced salt water into the San Andres Formation underlying the Eunice Monument South unit, which we will refer to as the MSU. The Commission's orders approving the unit that were issued approximately 40 years ago included the San Andres Formation within the unitized interval. Goodnight's injection causes waste and impairs the correlative rights of each mineral interest owner in the unit, including the majority owners of the minerals, the state of New Mexico, which owns over 58%, and the United States, which owns over 19%, thereby interfering with Empire's operations of the unit. And in addition to the continuing injection that is ongoing, Goodnight proposes additional wells and to increase the injection rate in one well, which will only exacerbate the problem. Here you'll see a map of the MSU boundary. Empire also operates the MSU B to the northwest and the AGU unit to the southeast. And as we know, in these cases, we are looking at the MSU specifically. For some background on the unit, the subject field was discovered in 1929. In 1984, the Commission approved the unitization of the MSU and included both the San Andres and Grayburg formations in the unitized interval. At that time, it was estimated that an additional 64.2 million barrels of oil could be recovered by water flooding the reservoir. Since that time, the MSU has produced approximately 25 million barrels of oil. The unit was first operated by Gulf Oil Corporation, which was subsequently rebranded as Chevron. In 2004, XTO acquired Chevron's interest, and XTO operated the unit from 2004 to 2021. Empire acquired XTO's interest and became the successor operator in March of 2021. Empire acquired the MSU from XTO because of the significant potential for enhanced oil recovery in the San Andres ROZ, which is the residual oil zone, and the Grayburg. XTO's literature on the unit valued the ROZ at approximately $100 million. With respect to Goodnight's injection, Goodnight first began injecting water into the San Andres unitized interval of the MSU in July of 2020, and as of January 1st, 2025, has injected approximately 63 million barrels of water. Goodnight's injection far exceeds any other injection of produced water into the unitized interval of the MSU. Here you will see a map of Goodnight's proposed SWDs within the MSU. They are shown in the red stars, and there are 4 of them here. And you can see the injection rates and pressures listed there, and the rates are significant that are proposed. And as you can also see, these wells are included within sort of it's a concentrated small area. And these are only the 5 proposed wells that are at issue here. If you look at this map, you can see all of the existing wells as well as the proposed wells within the MSU. There are 9 of them, and we've also listed the injection rates there, and they are significant. And again, you can see this is a large amount of injection going into this area of the MSU and into the unitized interval. Goodnight also operates an additional 5 SWD wells within approximately 1 mile of the MSU, and another SWD well in the San Andres within 2.5 miles of the MSU. Goodnight has permitted an additional 2 wells within approximately 1.25 miles of the unit, which have not yet been drilled, and those are the Rocket and Verlander SWDs. As of January 2025, the total amount of incompatible saltwater injected by Goodnight within or near Empire's operations is at least 126 million barrels of water. Sorry. Empire's evidence demonstrates that Goodnight's injection to date and proposed injection into the future adversely impacts Empire's ability to recover hydrocarbons in the unitized interval, including both the Grayburg and the San Andres, by, among other things, pressuring up the San Andres Reservoir to levels above the original pressure, requiring Empire to operate its CO2 tertiary recovery project at a higher pressure than necessary, and requiring Empire to inject the produced water into another zone to make room for the CO2 to avoid fracturing the formation. Further, repressurization of the San Andres increases water influx into the Grayburg Formation through natural fractures, and that is prematurely watering out Empire's Grayburg producers. Let's talk for a minute about the applicable law and the burden of proof, as well as the issues to be decided. And I think all of my slides are important. This might be the most important slide from my perspective. The New Mexico Oil and Gas Act requires the Commission to prevent waste of hydrocarbons and protect correlative rights. Under the Act, the Commission is charged with issuing orders, and this is a quote, to prevent the drowning by water of any stratum or part thereof capable of producing oil or gas, or both oil and gas in paying quantities, and to prevent the premature and irregular encroachment of water or any other kind of water encroachment that reduces or tends to reduce the total ultimate recovery of crude oil, petroleum, or gas, or both oil and gas from any pool. Goodnight has incorrectly focused on the first phrase of this statute, which refers to paying quantities, and ignores the rest. This argument violates New Mexico's rules of statutory construction, which require that statutes be construed in their entirety. In addition, the provision is included in the Commission's enumeration of powers and must be read broadly. Goodnight also misconstrues the term production and paying quantities. Under New Mexico law, that term means only that income generated from oil and gas production exceeds operating cost. This analysis does not include capital cost or investment. To the extent that Goodnight's witnesses focus on the economic aspects of a proposed tertiary recovery project, that focus is failing to comply with the statute and ignores the actual definition under New Mexico law of production and paying quantities. With respect to the burden of proof, I think we should all agree that administrative proceedings are subject to the common law rule that the moving party bears the burden of proof. The party bringing the application before the Commission therefore bears the burden of proving by a preponderance of the evidence that it is entitled to the relief requested in the application. Here, Goodnight bears the burden of proving by a preponderance of the evidence that its proposed injection will not result in waste or impair correlative rights, and Empire bears the burden of proving on its applications to revoke Goodnight's permits that the injection is resulting in waste or impairing correlative rights. And I'm raising that issue here because Goodnight has argued in various motions that Empire bears the burden of proof somehow on all of the applications, and that's not correct. It's not a correct statement of the law. With respect to the issues to be decided here, those have been addressed already by the Commission in its joint order on the scope of the hearing. And that order states, at said hearing, the parties shall submit all evidence, testimony, and legal argument on the issue of the existence, extent of, and possible interference with a residual oil zone underlying the Eunice Monument South Unit, the MSU, by produced water injection activities undertaken by Goodnight. So that is what we are all here to address and that the commission will decide. Empire's witness testimony will demonstrate that a RAS underlines the MSU and that Goodnight's injection is interfering with it. Empire relies on voluminous geological and engineering data that supports its position, while Goodnight disregards fundamental geology. Goodnight spends the majority of its time trying to explain away evidence rather than supporting its case with affirmative evidence, likely because Goodnight's evidence is weak and flawed, as Empire's witnesses will explain. And to introduce those witnesses, these are the folks you'll be hearing from during the hearing. You'll hear from Jack Wheeler. He is the Empire Senior Vice President of Land and Legal. He will testify regarding the creation and history of the MSU, Empire's acquisition of the MSU and its operations, division and commission orders relating to the unit, and the location of Goodnight's proposed and currently active or permitted SWDs within the MSU. Dr. Robert Lindsay is a consulting geologist. Dr. Lindsay wrote his PhD dissertation on the MSU, and he is the foremost authority on it. He will testify to his characterization of the geology of the San Andres and Grayburg Reservoir, including selection of the top of the San Andres, the presence of a residual oil zone within the San Andres, identifiable vertical fractures within the San Andres and Grayburg that allow for vertical migration of injected salt water from the San Andres into the Grayburg, and the lack of an effective geologic seal between the Grayburg and San Andres. You'll hear from Galen Dilwyn, a consulting log analyst with NewTek. He will testify on the procedures that NewTek used to determine oil saturations of the Grayburg water flooded interval and the San Andres RAS in 7 key wells at the MSU. He will address the new look process for determining rock properties and oil saturation in carbonate reservoirs, sensitivities run on the model, and determination that a RAS interval exists at the MSU. Joseph McShane is a geologist, a petroleum geologist with Empire. He will testify regarding his experience reviewing and studying the unitized Grayburg San Andres interval in the MSU, including a geologic overview, cross sections showing proposed and active Goodnight wells injecting into the interval, subsea structure maps of the Grayburg and San Andres, NewTek's log analysis of oil in place, proof of the RAS in the San Andres, and the lack of a geologic barrier between the Grayburg and San Andres. Ryan Bailey, a consulting geologist with Ops Geologic, will testify in rebuttal to Mr. Preston McGuire that Goodnight's selection of a deeper top for the San Andres reduces Goodnight's estimate of the oil in place for the San Andres RAS. Goodnight does not recognize the Lovington sand as a marker within the upper San Andres, and many of their picks for top of San Andres are at this sand. And there is considerable oil in place in both the upper and lower San Andres based on Ops Geologic's log interpretation and mapping. Stanley Burkhead is a consulting geologist with Ops Geologic as well. He will testify that Goodnight's estimate of oil saturation is pessimistic due to the log parameters and rock fascias utilized in the interpretation. Goodnight's oil in place estimate is low due to the use of a San Andres structure top provided to expert witness Davidson by Goodnight, and that there is high oil saturation. There are high oil saturation intervals in both the upper and lower San Andres, which Goodnight failed to identify due to its interpretation techniques. Dr. Bob Trentham is a geologist as well. He will testify about the RAS fairways that developed in New Mexico and Texas, leaving large volumes of residual oil beneath main pay zones. Those are brown fields, and isolated with no main pay, which are green fields. He will talk about CO2 enhanced oil recovery, success at the Seminole RAS interval, which is a brown field and has produced 20,000 barrels of oil per day for over 10 years. He will talk about similarities in the success of the CO2 enhanced oil recovery project at Tall Cotton, which is a green field, where no commercial oil production had been established prior to CO2 injection. And he will address core and log information and state that that confirms the presence of a ROS at the MSU, the MSU-B, and the AGU. Lawrence Melzer is a geological engineer. He will testify about the use of enhanced oil recovery techniques, including CO2, to recover previously unproduced residual oil zones around the world, including in the Permian Basin. He will provide estimates of the recoverable ROS resources at the MSU, explain how SWD injection into those reservoirs will severely impair the ROS for both oil exploration and CO2 storage, thereby creating waste. Frank Merrick is a consulting engineer. He will testify to his evaluation of the impact of existing SWD operations on waterflood projects in the MSU, including his analysis of cross-sections across the unit that show oil saturations, the ways in which injection and further injection of produced water into the unitized interval detrimentally impacts Empire's ability to recover hydrocarbons from the ROS and therefore results in waste. Dr. James Buckwalter is a consulting reservoir engineer. He will testify regarding his reservoir model that he constructed for the MSU, MSU-B, and AGU waterflood units in the San Andres ROS interval. To obtain pressure and production history match, he required that water influx from the San Andres occur with the start of production in the 1930s. And he will explain that Goodnight is pressuring up the San Andres at a rate of at least 4 PSIs for every million barrels of water injected, and that this will result in 50,000 barrels of water per day entering the Grayburg producing interval within the next 2 years due to higher San Andres pressure. And last but not least, Mr. William West is Empire's Senior Vice President of Operations. He will testify about the volumes of Goodnight's SWD injections to date, their quantifiable impacts on the MSU secondary recovery operations. He will explain that there's evidence of communication between the San Andres and Grayburg formations. He will provide evidence that there was a ROS in the San Andres, discuss the estimated area of SWD exposure due to the salt water within the MSU, describe SWD impacts on secondary and tertiary recovery projects going forward, and explain how Goodnight's down dip disposal will impact the up dip portions of the San Andres and ultimately enter the Grayburg. I am going to attempt some technical wizardry here and show you a simulation that is pretty short. It's about 2 minutes. The Eunice Monument South unit is composed of stacked sequences of carbonate material that have been naturally fractured during structure uplift of the San Andres and Grayburg formations. Goodnight's SWDs are impacting the residual oil zone within the San Andres, and water is moving through those natural fractures into the Grayburg. So the simulation will give you an idea of the fluid movement in the reservoir. So this is showing you the map, the line of cross section. And this is a cross section through the reservoir showing the San Andres is structurally high to Goodnight's Rhino SWD as we move to the northeast. And it was during this uplift of the structure that natural fractures formed in the Grayburg and San Andres. You can see here that Goodnight saltwater injection is moving up dip to Empire's water supply wells and through natural fractures into the Grayburg. And here we see a geologic slice of the reservoir showing the Grayburg and a major portion of the San Andres filled with oil. The Grayburg and San Andreas intervals were concentrated with oil until tectonic forces millions of years ago caused the oil from the San Andreas to be displaced with water, leaving a residual oil zone. Production began in the Grayburg interval in the 1930s, and in 1986, a water flood was implemented in the Grayburg. The water flood in the Grayburg displaces the oil and leaves a residual oil saturation in the Grayburg. Here we see the pressures in the San Andreas and Grayburg, with pressure in the San Andreas currently being higher. As Goodnight continues to inject salt water, the pressure in the San Andreas increases and builds up. And as the pressure builds up, the water moves through the natural fractures into the Grayburg. The CO2 flood begins to recover oil from the residual oil zone in the San Andreas while continuing to water flood the Grayburg. And since it's likely that CO2 will move through the natural fractures into the Grayburg area above the CO2 flood will also be prepared for CO2 breakthrough. Empire's evidence proves that a ROS exists within the San Andreas Formation in the MSU. The selection of the tops of the San Andreas Formation here is key. Goodnight concedes there is a ROS, but claims it is in the Grayburg based on its flawed selection of the top of the San Andreas. This is a high-level summary of Empire's evidence that will be addressed by our witnesses. The existence of a ROS within the San Andreas underlying the MSU and the surrounding area is confirmed by core on the MSU 679 and RR Bell number 4 wells within the unit, and the North Monument Grayburg San Andreas Unit 522 well, previously operated by Amarada Hess, which is located near the MSU-B. So Empire's witnesses and the analysis in this case is based on the actual core from those wells. The self-affirmed statement of engineer Lawrence Melzer, which is our Exhibit C, states, the evidence from the cores taken at depth in the San Andreas clearly demonstrates a residual oil zone of at least 250 feet beneath the two units. Oil saturations obtained in the MSU 679 conventional core and shown in Preston McGuire's Exhibit B32 show oil saturations greater than 20% in the San Andreas down to 4,252 measured depth, or minus 652 feet subsea. Goodnight uses an incorrect San Andreas top of minus 672 subsea, whereas Empire's corrected top of the San Andreas is minus 548 subsea. This demonstrates the problem with Goodnight picking the top of the San Andreas deep to avoid saltwater disposal into the Grayburg interval. By selecting a proper San Andreas depth for this down depth well, a 104 ROS column exists. And you can see that on this exhibit. This is one of Goodnight's exhibit. It's Preston McGuire's Exhibit B32. Goodnight, Empire's notes are shown in yellow, as it's also one of our rebuttal exhibits to Mr. William West's testimony. And it shows that Goodnight uses a San Andreas top of minus 672, but the actual core showed a higher top of minus 548. So that's 124 feet higher than Goodnight's pick. And if we use Goodnight's estimate of where the oil saturation is greater than 20%, this shows there is 104 feet of ROS, which Goodnight has excluded from its estimates of oil in place. So this really shows the fundamental problem with their analysis. Goodnight indicated during the Piazza hearing on that well in its Exhibit C18, which is our rebuttal exhibit N-2, which I'm going to show you, that while selecting the top of the San Andreas for water disposal, Goodnight was asked by OCD to use the deeper pick because it would give greater offset to the Grayburg production. So this is that exhibit from the Piazza hearing, and it's Exhibit N2, and our rebuttal in the yellow notes are Empire's. And it states that Goodnight confirmed in their SWD application on Piazza that they had selected a deeper pick than what could have been normal to provide greater offset to the Grayberg production. And they indicate that they continue to use these deeper picks. So that shows the reason for their picks rather than the actual geology. XTO confirmed that both the San Andres and Grayberg have ROS intervals when it owned the unit. This is one of our exhibits that shows the information that XTO had provided in a cross-section regarding the wells, and it demonstrates the existence of the ROS. We have colored it in our notes. Empire's notes are in yellow. Those are Mr. West's notes. And it shows the Grayberg and San Andres ROS intervals. The coloration shows the Grayberg transition zone, an area where San Andres has moved hydrocarbon. The movable hydrocarbons are also shown. And Goodnight's witness, Mr. William Knights, confirmed that both the MSU 658 and 660 wells both tested oil in this up-dip portion of the San Andres. The existence of a ROS in the San Andres is further confirmed by open hole logs and mud logs, which will be discussed by Empire's witnesses. I've provided citations for some of those exhibits here. We will show them during the hearing. For example, the MSU 660 drilling mud log shows good to yellow fluorescence with regions of good cut and strong gas shows across 150 feet of the San Andres. These other wells also that I've identified here show the existence of a ROS in the San Andres. Now for a summary of Goodnight's evidence. Preston McGuire is the only Goodnight witness who picked formation tops. All of the other Goodnight witnesses relied on his picks and did not do any independent evaluation. Mr. McGuire is a geologist, but his formation top picks rely entirely on reservoir engineering principles, including pressure data. He ignores the voluminous geological data. As Dr. Lindsay states in his rebuttal, you should never, ever pick formation tops using engineering data, especially when geological data is available. And this area is very well studied geologically. Dr. Lindsay discusses that extensively in his testimony. Mr. McGuire's rebuttal does not address Empire's evidence on this issue. He instead focuses on other matters. With respect to the oil saturations in the San Andres, Empire witness Dr. Lindsay explains that core analysis from the Empire 679 well and the RR Bell number 4 show sufficient oil saturations to reach a conclusion that the San Andres has a ROS, irrespective of whether it was termed as non-productive in 1984. Similarly, Empire's witness from New Tech, Galen Dillowin, opines based on wireline logs for 10 wells, there is oil saturation in the San Andres. And I provided a quote from his testimony there. He states the San Andres and Grayberg are primarily a dolomitic rock with some interspersed limestones, and that both formations show evidence of hydrocarbon saturation. With respect to Goodnight's evidence on oil saturation, they rely primarily on the lack of oil produced by water supply wells within the MSU. But as Empire's witnesses extensively explain, a residual oil zone can only be produced with CO2 tertiary recovery. So the lack of production of oil through water supply wells is irrelevant, essentially. Goodnight concedes that 2 wells have tested oil in the San Andres, the MSU 658 and the MSU 660. This demonstrates the existence of movable oil, which Goodnight saltwater disposal operations are pushing off lease and outside of the unit. Goodnight's contention that the ROS exist only in the Grayberg rest on the misidentification of the top of the San Andres formation. And as I mentioned earlier and showed you the slide, Goodnight admits that it picked the top lower at the Oil Conservation Division's recommendation to increase separation for purposes of water disposal. Empire will present extensive evidence that Goodnight's existing and proposed injection within the MSU is damaging the ROS and impairing correlative rights. There is no impermeable barrier between the Grayberg, the San Andres ROS, and Goodnight's injection. With respect to Empire's evidence, as explained by Dr. Lindsay in his direct and rebuttal, natural fractures exist in both the Grayberg and San Andres formations and promote communication between the 2 intervals. And Dr. Lindsay has provided the actual fracture studies that confirm this conclusion. The San Andres reservoir pressure dropped from 1747 psi's at minus 430 feet subsea to 1245 psi's, which is over a 28% depletion by April 1986, with limited production from the San Andres. And this was measured in the MSU 211 well. And this is important because it shows prior to water flooding, that production from the Grayburg caused a pressure drop in the San Andres. So that confirms that there was not an impermeable barrier between the two intervals. Empire has also provided water chemistry results that confirm there is no impermeable barrier between the injection interval and the San Andres and the Grayburg. Dr. Lindsay discusses those studies. He explains that plumes of water came from the San Andres, which contains low salinity water that is sulfate rich. The presence of San Andres sulfate water mixing with the Grayburg barium ions and forming barium sulfate scale prior to the water flood shows that San Andres water entered the Grayburg prior to the water flood, and therefore there's no impermeable barrier, and there is communication between the zones. This interference is also shown by Dr. Buckwalter's model. Dr. Trentham, another of Empire's experts, similarly concludes that core log information confirms the presence of a ROS, and that Goodnight's continued injection of off-lease water will greatly diminish or destroy Empire's ability to use tertiary recovery in the unit. Empire has seen an increase in chlorides in 4 wells near the Goodnight SWD wells, which also indicates that San Andres water is entering the Grayburg Formation. With respect to Goodnight's evidence, Goodnight contends that a 200-foot barrier exists across the MSU, separating the zone in which Goodnight injects incompatible water from the ROSs that exist in the Grayburg and San Andres. Goodnight's witness, Mr. McGuire, states that additional engineering evidence addressed in their testimony confirms this assessment. The problem with this representation is that the cross sections provided by Mr. McGuire do not show a continuous 200-foot barrier. And each of Goodnight's witnesses relied on Mr. McGuire's representations that a 200-foot barrier divides Goodnight's disposal zone from the existing residual oil zones. And I'm going to show you here, I need to, I think, escape from this for one moment. I'm going to show you Mr. McGuire's cross section that he relies on and that all of Goodnight's witnesses rely on. And they claim that, and I know this is small, so it's a little bit difficult to read, but the main point here is, for my purpose right now, is that they claim that the solid colored zones constitute impermeable barriers between the injection zones. But as you can see, and unfortunately I just lost it, there it is. They are not impermeable barriers. You can see a lot of white space there. The white space would allow for flow. So I'm sure Goodnight's witnesses, they rely on that, and it's not a correct assessment. Go back to my slide. Goodnight's injection is also damaging the ROS and impairing correlative rights because it is increasing formation pressure. The injection causes overpressured formations. This overpressurization exacerbates existing and causes additional fractures and collapsed breccia. Injection of foreign water is also damaging Empire's producing wells. Goodnight is pressuring up the San Andres at a rate of 4 to 7 psi's per 1 million barrels of water injected. By its disposal of over 200,000 barrels of water per day, Goodnight will pressure up the San Andres by 292 to 511 psi's in 1 year's time. This will require that Empire use more CO2 for the San Andres CO2 flood than if the CO2 flood is operated at a lower pressure. The disposed water is also known to cause scaling and corrosion, as evidenced by a workover on Goodnight's Rhino SWD well in October of 2024. The disposal water causes scaling downhole due to high levels of sodium and calcium in the disposal water mixing with sulfates in the San Andres water. So that's another problem that this injection is causing. Due to the San Andreas pressure increase, water influx into the Grayburg through natural fractures will increase and impact Empire's Grayburg water flood. The areas where water entered from the San Andreas into the Grayburg was mapped at the AGU, but can be estimated at the MSU by the high water production volumes seen in the crustal areas at the MSU prior to the water flood. There was an edge water drive from the Goat Seep Aquifer, Grayburg, prior to the water flood, but it was insufficient to cause these high water volumes. The petroleum geology, using the correct San Andreas structure top geochemistry, which includes the San Andreas sulfate water appearing in the Grayburg, and petrophysics, which includes the core and log analysis showing oil in the San Andreas, all show that there is a ROS in the San Andreas and that there is communication between the San Andreas and the Grayburg. Physics tells us that pressure increases in the San Andreas, and as that occurs, the water influx will increase and this problem will worsen. To address OCD's concern about the migration of injected water to the Capitan Reef, the first point is that this issue is outside the scope of the hearing because the commission must first determine if there is a ROS within the San Andreas and if Goodnight's injection is interfering with correlative rights. Dr. Lindsay's direct testimony also addresses OCD's concern. He states there is not a migration pathway between the unitized interval and the Capitan Reef. Empire's injection, including for a CO2 project, is vastly different from Goodnight's injection. Goodnight's injection involves high volumes of water from other formations and areas into the San Andreas, whereas Empire is only injecting water that was produced by the San Andreas and Grayburg within the MSU back into the same formations. Goodnight's injection is causing formation damage while Empire's is not. OCD does not present any evidence that migration or contamination of the Capitan Reef is actually occurring. And at this time, the commission should not require Empire to implement a monitoring project. The request is unnecessary because OCD does not provide any evidence of a migration pathway, and voluminous geological evidence shows there is no such pathway. In conclusion, Empire's evidence resoundingly demonstrates that there is a ROS within the San Andreas underlying the MSU, and that Goodnight's injection is interfering with Empire's unitized interval and violating correlative rights. Empire's applications to revoke Goodnight's permits should be granted, and Goodnight's applications for approval of additional wells and to increase its injection rate should be denied. Thank you very much for your time.
Mr. Hearing Examiner, press your button. Your microphone. There you go.
Thank you, Ms. Hardy. Let's see, I see it's 10:22. Why don't we take a 10-minute break? How about we come back at 10:35? Give everybody a little bit of a break and you can collect your thoughts, Mr. Rankin.
Thank you.
All right. Yeah, sorry. Okay, Mr. Bacher, are you?
Yes.
Okay. All right, folks, let's get on with it. You've had an extra 4 minutes, so just for the record. All right, I take it then that Goodnight will make their opening statement at this point, and I suspect we'll hear something a little bit different.
Thank you, Mr. Hearing Officer. May it please the commission, Chairman Rosados, Commissioner Bloom, who's in an absentia, and Commissioner Ampoma. In these consolidated cases, Goodnight seeks approval for 5 new produced water disposal wells and authorization to increase the injection rate in 1 existing well. All of these wells target a disposal zone in the San Andres Formation, and all are within the exterior boundaries of the Eunice Monument South Unit, or EMSU, that is operated by Empire. For the existing well, which is called the Andre Dawson in case number 23775, Goodnight requests an increase in the injection rate from 25,000 barrels per day up to a maximum of 40,000 barrels per day. As explained in the testimony, this increase in the maximum rate is just to accommodate long-term peak loads. Goodnight has no intention of running its wells or any of its wells at that maximum rate for prolonged periods. Goodnight's approach is to distribute its load over multiple wells and over a large area. Now, the testimony will show that Goodnight has operated its wells in the EMSU at an average injection rate of less than 15,000 barrels of water per day. And that is the rate they expect to maintain in all of its wells. 4 of Goodnight's cases request approval for new wells to dispose into the San Andres. Those are under case numbers 23614 and through 23617. Now, all the details on those wells and the request and the technical issues are in the testimony. The 5th proposed new well is under case number 24123. Now, that's the de novo case that the division in which the division denied Goodnight its permit previously back in November of 23. We believe the division's order was erroneous. The evidentiary record simply does not support the order. There was no evidence that the proposed injection would interfere with the EMSU operations, cause waste, or impair correlative rights. There just was no evidence then, and there's still no evidence today. Now, as the testimony will show, all 5 of Goodnight's proposed new wells and the Andre Dawson rate increase should be improved. In addition to Goodnight's 6 cases, we also have Empire's 4 applications to revoke Goodnight's injection authority in its 4 existing SWDs in the unit. What the commission must decide. Okay, at issue and what the commission ultimately needs to decide is whether Goodnight's existing and proposed injection will cause waste or impair correlative rights in the EMSU. It's that simple. But there are threshold issues that underlie those ultimate decisions that the commission must evaluate and decide first, including whether Goodnight's San Andres disposal zone in the EMSU contains economic accumulations of oil that are commercially recoverable through a CO2 flood, whether any stratum within the EMSU that is capable of producing oil in paying quantities is being drowned out by water from Goodnight's disposal, and whether there's a competent geologic seal or barrier that effectively isolates Goodnight's disposal within the San Andres. Separately, the commission also must decide whether the San Andres is geologically or hydrologically connected to the Capitan Reef Aquifer or to any other underground source of drinking water. The testimony that you're going to be reviewing, or you have already started reviewing, hopefully, and that you're going to hear next week, will establish that the San Andres in the EMSU is an aquifer, not a hydrocarbon reservoir. And I'm talking specifically about Goodnight's disposal zone, okay? Because it is an aquifer, there are no commercial accumulations of oil in that zone. That means disposal of produced water can't be causing waste or impairing correlative rights, nor is it watering out any zone capable of producing oil or gas in paying quantities. And because there is a competent and effective seal that isolates the disposal zone from EMSU operations above, there's no impairment to correlative rights or to the production in the EMSU, and therefore no waste. Much of the evidence supporting these determinations is highly technical. and complex, much like the carbonate shelf system that makes up the EMSU itself. But while the subject matter and evidence at the core of this dispute are technical, with a heavy focus on petrophysics, petroleum geology, geochemistry, and geology, fundamental tenets of logic and reason ultimately carry the day, okay? So don't get too concerned or swept up in all the technical issues here, because ultimately logic and reason carry the day. Even without an advanced degree in petroleum engineering or petrophysics, the weight and force of the evidence is clear and supports granting Goodnight's applications and denying Empire's effort to revoke them. Let me give you a little bit of background and context on what we're talking about here. Before I get into the details, I want to go into this history and the background of the San Andres in this area. And I'm going to start sharing my screen, and I'm going to show you on the screen here is actually something that Empire didn't show you in its opening. I want to point out first, before I get into the details of this map, that in 1965, the New Mexico State Engineer declared the San Andres in this area to be an aquifer subject to permitting requirements for beneficial use. The EMSU's operator at the time, when it was first approved back in the 1980s, went to the state engineer and permitted 6 water supply wells in the San Andres through the state engineer back in the 1980s as a source for water flood operations. In fact, the whole reason the San Andres was included in the EMSU was because it was the only source of water capable of supplying the volumes needed for the water flood in the EMSU. Even though the San Andres had no history of primary production, was known to be non-productive, it was included erroneously as part of the unitized interval. It should never have been included. The commission has no authority to unitize formations that are aquifers. And the evidence presented to the commission was that the San Andres would be used as a water supply, and that water flood injection would be limited to the oil column in the Grayburg and the lower Penrose above the San Andres. But well before it was declared an underground water basin, the San Andres was for years of formation targeted for produced water disposal since at least the 1950s. More than 3 decades before the unit was created in 1984. On this map are all the wells that have been approved and actively injecting into the San Andres in and around the 3 units that Empire operates. The first San Andres disposal well in the area that would become the EMSU started injecting produced water in 1960. And that's this well up here. It's a little yellow triangle here. And you'll see on each of these wells is a date of first injection and the cumulative volumes as of today, okay? For some of the wells, we don't have complete records because they were injecting before the division started requiring reporting of all the injected volumes, okay? So the first well there is the EME number 33M. It's less than 200 feet from the boundary of the unit and is operated now by Rice Operating Company, one of the interveners in this case, and it has injected more than 60 million barrels of produced water to date. Then, nearest to the unit boundaries today, in 1966, a saltwater disposal well was approved and started injecting what is now the EMSU. It's actually within the boundaries, and that's this well here in the southwest corner. It's the EME SWD number 21, and it's operated by Permian Line Service, who also is an intervener in this case, and it has injected more than 43 million barrels of water to date. As you can see, there are dozens of additional SWDs that have been approved in and around the EMSU and Empire's 2 other units going back to 1952. Most of them are still active. Since the 50s, in every decade, numerous additional SWDs started disposal operations within this 5-mile area, within the 5-mile area surrounding Empire's 3 units. In 1987, Gulf Oil itself, who was the operator of the EMSU, converted one of its wells that actually was the unit log well to a active disposal well in the San Andres. And that well has continued to be operated by Empire as recently as late in 2024. I'm showing this map because Empire's experts and their experts, including their reservoir modeler, says that all SWDs should be shut in and banned within a 5-mile radius around Empire's 3 units. In Empire's testimony, Mr. William West says all SWDs within 2 miles should be shut in and banned, and no SWDs should be allowed within a 5-mile radius unless all the working interest owners in these 3 units approve. More than 60 SWDs are within that 5-mile radius. That's a lot of SWDs. More than 90 have been approved for disposal in the San Andres in the area. In fact, in the early 90s, the division even established a special pool code for San Andres disposal wells that it continues to use today. The history and context is important to understand here because Empire and the EMSU before it came to existing disposal in the San Andres within the EMSU. That disposal was pre-existing. Empire knew or should have known about the San Andres disposal when it bought the properties from XTO, but remarkably, they somehow only discovered it afterwards. Based on the fact that the disposal into San Andres existed before the EMSU was created and continued to be approved even after the EMSU was formed, Goodnight Midstream acted in reliance on decades of authorized approvals for SWDs and filed applications for its own disposal wells, but only after the following. First, Goodnight met with XTO, who was then the operator of the EMSU, to discuss potential locations for their own SWDs in the unit. Second, Rice Operating filed for and the OCD approved 2 additional SWDs in the EMSU in 2018. And that's over here, this little pink well, which has a date of first injection of 11/20. This is the P15 well, and is now owned and operated by Pilot, one of the interveners in this case. And the other well is down here in the maroon color, the darker maroon color. That's the N11. That is owned and operated now by Permian Line Service. After Rice received its permits in 2018, Goodnight proceeded to file applications for 4 of its own SWDs in the unit between 2019 and 2020. The first was the Sosa SWD, which was filed in 2019. It's one of these 4 wells down here in this little grouping. It was approved by the OCD in March of 2020. XTO did not object. Next was the Rhino SWD, again, one of these 4 in this little grouping. It was converted from a Devonian injection well into a San Andres. That application was filed in 2019 and approved by the division in 2020. No objection from XTO. Next, Goodnight filed 2 applications for the Dawson and Banks wells. Those were filed in 2020 and approved by OCD in February of 2022. Again, no objection from XTO. The evidence will show that Goodnight's existing SWDs and its pending applications in the unit were filed in sequence and in reliance on the division's long history of approving SWDs in the San Andres, including within the EMSU, and in reliance on the long history that the San Andres was an aquifer and a water management source. Now, what does that reliance look like? Okay. It looks like this: $100 million pipeline that Goodnight built, moving produced water from areas of high intensity Delaware Basin development near where the OCD has set up seismic response areas to Goodnight's saltwater disposal field around the EMSU. This is what's at stake in today's hearing. Now, Empire's claims, given the history of the San Andres, is, given the history here, what's the problem? Okay, what's the problem with OCD's Goodnight's operations? Well, Empire is suddenly saying that there's overlooked oil in the San Andres, and they have a plan to produce it. They say that there's 900 million barrels of oil across their 3 units. It's a remarkable claim, given that they bought the 3 units from XTO for a final adjusted price of just about $16 million. The purchase price was $17 million. After all adjustments were made, it was $16 million. According to Empire, injection of produced water into the San Andres is going to make it costlier for them to produce CO2 from their ROZ zone. And it's impacting their water flood operations. And that the injection from Goodnight is causing water to migrate into the Grayburg, causing corrosion, scale, and encroaching on their water flood operations. Now, as the applicant seeking to revoke Goodnight's injection authority and to overturn decades of long-established regulatory precedent by converting the San Andres from a water management zone for produced water disposal and water production into an oil reservoir, it's Empire's burden to bring forward sufficient facts to prove those claims under their applications. There's no dispute about that. The problem is they keep changing their story. They keep shifting their position. They keep revising their analyses and their models every time Goodnight's points out a fundamental flaw in their approach. And they keep trying to litigate their claims by ambush, starting with the very first contest between these parties in 2022. Back then, in the Piazza case, Goodnight made a very simple discovery request. Provide all the documents that reflect the presence or absence of oil in the San Andres within the EMSU. One request, just give us what you got. Empire put up a big fight and resisted. The division agreed with us and issued an order compelling the discovery. Empire gave us 7 documents. 4 documents were general papers and presentations on ROZ and the public announcement of Empire's purchase. The others were marginally responsive to the discovery request, some details on some of their wells. Nothing about an ROZ in the San Andres. We show up to hearing, and Empire presents as part of their evidence and testimony brochures from XTO that they withheld from discovery in an effort to ambush us at the hearing. The hearing officer admitted the exhibits over Goodnight's objections. The same thing happened at the outset of these very cases, before the division 1 year later in 2023, only on a much bigger scale. Just days before the hearing, Goodnight was forced to compel production and continue that hearing from the day it was set, when it became apparent that Empire failed to comply with its discovery obligations, and the cases were eventually referred to the commission. Now, at the commission, Empire is playing the same game, and still no consequences. After the parties filed direct testimony and exhibits in August 2024, Empire saw Goodnight's petrophysics and oil in place analyses from its experts at Netherlands Sewell and acted quickly to prepare a revised petrophysics analysis, directing their witness, Mr. Galen Dillon, with NewTek, to undertake a different analysis using different inputs and different parameters based on measured water saturation in his cord logs. Information that Empire had all along from the beginning. Now, based on that new analysis, Empire submitted revised petrophysics testimony and revised geology testimony with a new oil in place analysis in December, more than 3 months after the deadline to submit direct testimony, without seeking leave from the commission to do so and without conferring with counsel from the other parties beforehand. Now, we reached agreement to file the revised testimony and to file a notice, okay, explaining what was changed, why it was changed, and the justification for the timing. So that is all part of the record. Now, that revision in December, required Goodnight's experts and counsel to throw away all the work they've been doing the 3 months prior on the original analysis that they'd done and start over on a new one in December. Remarkably, when asked which version of his testimony he stood behind, Mr. Dillon testified in his deposition that he stood behind his original analysis and testimony, not the revised one that Empire had instructed him to prepare. Then, a month after filing the revised petrophysics and oil in place testimonies, Empire disclosed in early January that they were going to present 2 new witnesses, providing a different petrophysical analysis with different assumptions and different inputs, resulting in a different oil in place estimate based on a new stratigraphic analysis with new tops, for which Empire's new experts think where the San Andres is actually located. Now, we've had the underlying petrophysical log and digits for less than a week at this point, so we have not had time to fully evaluate them. But it's apparent that what they're doing is that they're calibrating their new log interpretations to a different cord log, not in the EMSU, and many of their San Andres top picks are different. We evaluated the top picks that they'd given us in discovery and that were used for their structure maps initially, and approximately half of the tops in their cross sections and their rebuttal testimony are different than what we had initially. So the fact that Empire has to keep changing their story while Goodnight's analysis has remained consistent and unwavering says just about all you need to know. But what is Empire's story, and how does all this technical stuff fit into it? Well, it appears that Empire's goal here is to confuse and obfuscate, okay? That is most apparent in their testimony around what is or is not the San Andres. For example, all of Empire's evidence on the alleged migration of produced water is limited to what Empire calls the upper San Andres, the zone that Goodnight refers to as the Grayburg, not Goodnight's disposal zone. That interval, which is highlighted here in yellow, okay, whatever you want to call it, the upper San Andres or lower Grayburg, is not in dispute in these cases because it is above Goodnight's disposal zone and the perm barrier that we've identified. The only dispute is what to call it. But, you know, even that makes no difference. It's just semantics, okay? It has no bearing on the analysis of the technical issues in these cases, whether there's oil in Goodnight's disposal zone. And the evidence that Empire does present on this purported communication with the San Andres is purely conjectural. For example, Empire insists that the high sulfate San Andres water that was migrating into the Grayburg before the EMSU water flood even started in 1986, thereby establishing a history of communication between the zones, okay? But they have not presented any evidence of high sulfate San Andres water being produced from the Grayburg formation before water flood operations started. So there's no evidence that that's actually the case. And the evidence they do rely on to contend there's communication today, such as the geochemistry data that they rely on heavily, it's not diagnostic. It just doesn't provide the fingerprint that Empire claims. Looking for a San Andres fingerprint makes no sense, considering that approximately 350 million barrels or more of San Andres water has been injected into the Grayburg for more than 40 years, completely mixing the chemistry. But setting aside these evidentiary problems and the supposition that Empire makes and the conclusion Empire attempts to draw are all related entirely to what is essentially this upper San Andres zone, not Goodnight's disposal zone. Empire has presented no direct evidence showing communication between the disposal zone, here in blue, and the Grayburg, or even between the disposal zone and the upper San Andres. It's really important to understand this and to be clear about what depths Empire or its witnesses are referring to when they discuss the San Andres. By constantly referring to the interval above Goodnight's disposal zone as the San Andres, without specifying depths, Empire is sowing confusion about the two main issues in these cases. Whether there's communication between the disposal zone and the producing interval, whether there is an economic ROZ in Goodnight's disposal zone. Those are the two main issues, and it's important to understand what depths we're talking about. This confusion shows up across every main category of evidence that Empire puts forward. First, in the alleged fractures between the San Andres and Grayburg. Those are all premised on Dr. Lindsay's fracture analysis in his testimony, where Dr. Lindsay provides specific depths for his fracture study of a single-oriented core, the 679 well. The fracture study does not even go to the bottom of the Grayburg in his own analysis. It stops well short of what Empire itself calls the base of the Grayburg. Now, in his rebuttal testimony, Dr. Lindsay supplies additional testimony on two new fracture studies in the EMSUB to the northwest and the AGU to the southeast, miles away, but nothing new on the EMSU. But even then, he does not provide any depths or reference, for reference in either of his rebuttal testimony or in his backup documentation that he provided to us. You read it carefully, you'll see he does not specify where he says the fractures are, what zones. Now, if these additional fracture studies actually documented fractures going into the stratigraphic equivalent of what is Goodnight's perm barrier, you would expect to have seen that in his testimony. What specific depths is he talking about? But he doesn't include it. The second category of data where we see this confusion is in the reservoir pressure measurements from Mr. William West. He makes assumptions about what the pressures are at certain depths to show a purported pressure drawdown in the San Andres as a result of primary production in the Grayburg. He tries to show that there's communication between the formations. But the depths that he uses are well above the top of the barrier isolating Goodnight's disposal zone. So even if his pressure assumptions and calculations are correct, and there's significant problems with those, the depths he says, in fact, you'll see in the testimony that in our rebuttals that it doesn't actually establish communication. It does the opposite. It shows that the Grayberg is highly compartmentalized and there's not even communication within the vertical layers of the Grayberg itself. But even if his calculations and assumptions are right, the depths he says are in the San Andreas are not in Grayberg, in Goodnight's disposal zone. So his erroneous assumptions here on the pressures infects not just his testimony, but it infects and invalidates Empire's reservoir simulation that they put forward, which requires having an accurate starting reservoir pressure for Goodnight's disposal zone. Okay, he's far above it, and it's not an accurate representation of actually what's happening in the disposal zone. Third, we see this confusion continue with Empire's ROZ petrophysics and oil in place calculations across the EMSU, and you heard it in the opening. Empire complains that Goodnight has excluded roughly 200 vertical feet of the San Andreas from its ROZ calculations, resulting in a lower oil in place calculation for the San Andreas. But that claim is just plain false. Goodnight did not do its petrophysics or its oil in place analysis based on formations. And contrary to Empire's claims, Goodnight does not exclude the ROZ from its calculations, not at all. In fact, Goodnight's petrophysics and oil in place analysis are entirely agnostic with respect to what interval they're in, whether it's Grayberg or San Andreas. Goodnight's petrophysics is based on phase sheets changes, and the oil in place analysis is simply divided into tiers based on depth and reservoir quality, without regard to whether a certain interval is called the Grayberg or San Andreas. Under this approach, and this was at the discretion of our experts who said, look, there's a dispute over the tops. We're not going to get into the tops. We just want to know where the oil is. What does the rock say? Under this approach, the San Andreas top does not matter. What matters is whether there is any potential for economic oil and at what depths. Now, according to this analysis that Netherton Sewell conducted, nothing below minus 500 feet at a maximum subsea warrants economic evaluation. It doesn't matter to them. It doesn't matter to the analysis, whether that's the Grayberg or San Andreas. It's all about depth. In contrast, Empire overinflates its oil saturations, calculating mobile oil where well tests produced 100% water, and calculating high oil saturations where there's no oil staining in the core. Empire also includes additional vertical intervals in its ROZ calculations that are above Empire's disposal zone and not part of the dispute in this case, because they're outside of the disposal zone. This interval should not be calculated as if it is in the disposal zone. The bottom line, whatever you hear testimony about the San Andreas, without specifying depth, be aware whether the testimony relates to Goodnight's disposal zone or shallower intervals, because that's critical. Now, I want to get into the two main areas of dispute, okay, whether there's communication in fractures and whether there's oil or an ROZ. On the issue of communication between the San Andreas and the Grayberg, Empire has produced no data to support their claim that massive volumes of San Andreas water are pluming into the Grayberg. If they did, they would be able to show it in field-wide production, or at least in offsetting wells through well production data. But they haven't, and they can't. Empire has no production data to support this claim, so they went out and they got a reservoir modeler to create a simulation that provided them the answer that they want. The problem is that Goodnight's disposal volumes are just not showing up in the Grayberg, as Empire claims. Now, Empire's witness, Dr. Buckwalter, testified in his deposition that the EMSU was one of the hardest reservoirs that he has ever attempted to model. It took him more than 500 model runs to get what he called a field-wide match. Well, in his deposition, he explained his approach was simply trial and error. He started with a reservoir pressure, and he started with the initial production volumes, and he tried to do a match. And it took him 500 model runs, several months to do so. He said getting that match was like hitting the lottery. On the assumption that his field-wide match means that his model accurately reflects reality, his written testimony states that the San Andreas must be currently contributing about 24,000 barrels of water per day from the San Andreas into the Grayberg through fractures across the EMSU. That's 720,000 barrels a month to account for the water production in the EMSU. Now, over a 9-month period, that would be almost 6.5 million barrels of water that he says is allegedly pluming up from the San Andreas into the Grayberg. If his model were accurate, those volumes would be showing up in the Grayberg and Empire's field-wide production data. But we're just not seeing those volumes anywhere in production. In fact, Empire's actual field data shows something very different, okay? Here I'm showing you a slide from Mr. West's direct testimony, and I've highlighted some language. Empire's VP of Operations, Mr. West, testified that Empire is injecting 70,000 barrels of water per day as part of its water flood and producing about 70,000 barrels per day as part of the production from the Grayburg. In other words, Empire is producing about the same amount of water that they inject every day. That's current. Just looking at these numbers, Dr. Buckwalter is saying that nearly 1/3 of the volumes that Empire is injecting into the Grayburg every day is pluming up in, sorry, let me rephrase that. Just looking at these numbers, Dr. Buckwalter says that nearly 1/3 of the volumes, that Empire is injecting into the Grayburg every day is pluming up from the San Andres every day as well, 24,000 barrels a day. That means about 100,000 barrels of water actually is going into the Grayburg every day. 70,000 from Empire's water flood injection and 24,000 pluming up from the San Andres. But we're just not seeing those numbers. Okay, let's look at some of the actual recent numbers that Mr. West himself put in his testimony. These are production figures for a 9-month period from November 23 to July 24. Okay, these are daily average numbers. Okay, that means we have, if you were to calculate this out over that period, 9 months, there's about 19 million barrels of water that Empire is injecting and producing over that time. It's roughly the same in as going out. But according to Dr. Buckwalter, there should be more than 6 million barrels difference over these 9 months. There's not even a 200,000 barrel difference. Okay. Now, is the injection somehow affecting oil production? That's their claim. But here's a slide showing from Empire's own data, field-wide production data going back to 1970. Okay. There's no impact. In fact, the most recent month shows that that's the slowest or lowest decline over the entire period going back to 1970. Zooming in on this period from March of 2021, when Empire acquired and started operating the unit, okay, we see that in an interval that Mr. West identifies in his testimony in Exhibit I-18, where he purports that there's an unreasonable decline in oil between November 2023 and July 24. All he did was he subtracted July 24 from November 23 and he sees a big drop, but he's not telling you that the months after it rebounded. He's also not telling you that during that same period, there was if you look at the well count in the field, the well count's been going down over time, but production's been holding pretty constant. So we're not seeing an impact in produced water, and we're not seeing an impact in oil production or decline. There's just no abnormal decline and no impact. The water's just not showing up, and there's nothing indicating any problems with the EMSU operations. Empire's claim and its reliance on modeling and simulation that's not reflected in actual field data is just smoke and mirrors and does not match reality. Now, rather than plumes of San Andres water coming up into the Grayburg, what's actually happening is that there's edge water encroachment from the Grayburg and the Goat Seep. That's the answer to the water mystery in the EMSU. Only it's not a mystery. The encroachment from the Goat Seep and Edgewater moving into the Grayburg has been known about and written about since the 1930s, almost as long as the field has been producing. Throughout its long history, there's never been any discussion in the literature on the EMSU or EMSU well files at the division or division case files that there is San Andres water pluming up into the Grayburg through extensive natural fracturing, as Empire describes. Empire is trying to rewrite history here and reframe the facts to suit their story. In support, Empire points to a single 1996 Chevron paper. It addresses corrosion and scale problems that were encountered during the water flood due to the known incompatibility of the San Andres water in the Grayburg. The authors speculate, that apparently San Andres water was finding its way into some EMSU Grayburg producers in the wells and postulate that water may have entered the wellbore directly, not that the water was going into the Grayburg formation through fractures. The supposed bottom water, okay, also would not be water in communication with Grayburg's disposal zone. This again is that disputed area, the disputed interval that we say is above our permeability. It is above our permeability barrier, which is isolated from Goodnight's disposal. In short, there's no statement in this paper that the San Andreas is pluming into the Grayburg, nor is there any data or documentation attached or referenced to establish that. 2 years later, in 1998, another Chevron team published a paper in an SPE paper, Society for Professional Engineers, on a different topic involving the MSU, its terrible water flood conformance issues. Now, this paper's lead author was Chevron's Tracy Love. Chevron was the operator at the time. He was a petroleum engineer who was in charge of the water flood and production issues in the unit. The purpose of the paper was to diagnose water flood problems, design treatments, implement process improvements. And he explained that there was poor water flood conformance, and that caused Chevron to do a substantial project starting in 1996 to characterize the unit and to evaluate how they can improve the water flood. Reservoir characterization, he said, included mapping high perm streaks, doing material balance, tracking what goes in and what comes out, and other engineering calculations like zonal processing. In that paper, he identifies that the San Andreas as a source of water encroachment into the Grayburg. He states that there are plumes of unaccounted for, he does not state that there are plumes of unaccounted for water coming into the San Andreas, coming into the Grayburg from the San Andreas. He instead found all kinds of other problems, including rapid breakthrough, high perm streaks, injection into the gas cap, and other issues, but he didn't find any unaccounted for water from the San Andreas. 2 years later, Mr. Love testified at the division in 2000 over requested increases to surface injection pressures within the water flood. In that case, there was a dispute about the MSU water escaping from the water flood into the Penrose and Queen formations, impacting shallower formations. He was asked directly if Chevron had identified any unaccounted for water in the MSU, and he testified that that Chevron had conducted and completed a full field reservoir simulation for the EMSU, and that the only unaccounted for water was down dip edge water coming in from the Grayburg. 4 years after Chevron's corrosion paper in 1996 speculated about potential San Andreas water in the MSU wellbores, there was no further discussions about San Andreas water migrating into the Grayburg, no discussions of fractures, and no data or documentation showing that the San Andreas water ever plumed up into the Grayburg before the water flood or after. Finally, the definitive, tangible evidence that there is an aerially extensive, competent seal isolating its disposal zone here is the pressure difference between the disposal zone and the formations above. When drilling each of its wells, Goodnight has passed through a normally pressured zone in the Grayburg into a substantially underpressured interval in the disposal zone, where Goodnight has lost circulation and returns. They had the same experience at the same stratigraphic interval when they drilled each of their wells. The testimony and exhibits will show that there's just no data or documentation supporting the claim that the San Andreas water is migrating into the Grayburg, as Empire contends. Now on to the ROZ claims. This is the last main issue before the division, whether there's an ROZ in the EMSU. It's true that Goodnight's experts have identified a potential ROZ in the EMSU between approximately minus 350 feet subsea and a maximum of minus 500 feet subsea. That's about 200 feet above Goodnight's current injection disposal interval, depending on where you are on the structure. But according to Netherlands Sewell, nothing below that depth warrants further economic evaluation. According to them, there is ample data to make that assessment now. There's no need to do a pilot CO2 at that depth to confirm what we already know, especially not within the disposal zone. And they say even the potential ROZ identified in the main producing interval, the zone above minus 350, is going to require significant additional evaluation to determine if a CO2 project could even be economically viable in that zone. Why? Why is the success of even the shallower zones so uncertain? Because the EMSU is effectively a failed water flood. And the same reasons the water flood failed are likely going to cause CO2 flood to fail as well, especially a CO2 that's a water alternating gas flood. Empire notes at the time the EMSU water flood was approved, it was it was projected to produce 64.2 million barrels through waterflood operations. And Empire goes on to say that it has produced approximately 25 million barrels of oil since 1984. But that 25 million barrels of oil includes 14 million barrels of primary production. Okay, so between 1984 and when the water flood commenced, there was an additional 14 million barrels of primary production. That means the EMSU has produced only about 11 million barrels under the water flood. In the 1983 Technical Committee report, okay, which is an evidence in this case, they projected that the optimum recovery case would produce 63.2 million barrels of oil over a 30-year flood life, while the minimum recovery case would yield 23.7 million barrels over the same period. Having produced only 11 million barrels after nearly 40 years of water flood is a colossal failure. That is less than half of what the minimum recovery case was projected to be back in 1983. Now, the EMSU is a complex carbonate shelf system. It has dozens of sea level changes, has been subaerially exposed and dolomitized, resulting in substantial compartmentalization and severe conformance issues that have plagued the water flood's performance and effectiveness from the start, and it will plague a potential CO2 flood for exactly the same reasons. This complex carbonate system is a problem for CO2 flood in intervals, even with the highest oil concentrations far above Goodnight's disposal zone. But for Goodnight's disposal zone, where the uppermost 400 feet of aquifer contains an average oil saturation of less than 11%, according to the petrophysical analysis that we've done, which is far below the threshold oil concentrations of any known pilot CO2 or commercial CO2 project, there's no chance for economic ROZ. How can I say that with such confidence? Well, let's look what we know about ROZs. The definition of an ROZ comes from Goodnight's own experts. They've got two ROZ experts, Dr. Trentham and Mr. Stephen Melzer. This is from one of their papers and actually from their testimony in this case. It shows that the highest oil concentrations and saturations in the ROZ are the shallowest, and that oil saturations drop with depth. They also tell us that commercial oil saturations, or rather commercial ROZs, have oil saturations between about 20 and 40%. That's directly from numerous papers and presentations on record from Mr. Melzer and Dr. Trentham. And it's in the direct testimony, and it's restated and adopted by Empire in this pre-hearing statement as well. This next slide here is from Goodnight's witness, Preston McGuire. It reflects Mr. Melzer and Dr. Trentham's work on the Goldsmith-Landreth San Andres unit, which they referred to. And it shows that the recorded oil saturations in that core and where they placed the base of the ROZ in that field, right at 20%, where the oil saturations drop off. I'm going to note here, okay, that they call the 20% oil saturation point the limit of a commercial CO2 flood interval, because below that, saturations drop off below economic levels. Now, where you see that telltale drop off in the oil saturations at about 20%, that generally represents what they call the paleo oil water contact, according to them. The paleo water contact is the deepest point in the formation that was, at some point in the geologic time, previously saturated with oil until Mother Nature's water flood. Mother Nature's water flood is when the Permian Basin tilted, allowing massive volumes of meteoric water to flush through the Grayburg and San Andres, acting like a man-made water flood, sweeping oil out of formations to the south and southeast and up dip under a substantial hydraulic head. This next slide here shows the general path from Empire's testimony. Multiple pore volumes swept through the Grayburg and San Andres over millions of years until there was a shift in the Rio Grande Rift, cutting that hydraulic head off and essentially turning off Mother Nature's water flood. Note that the EMSU is right in the middle of the path of this Mother Nature's water flood. And Dr. Trentham measured the permeability in the San Andres here as high as 100 millidarcies. It's also worth noting that they also identified a geologic seal in the San Andres at the top. Now, before Mother Nature's water flood was turned off, so much water came through, just like a man-made water flood, that essentially all the mobile oil was swept out. All that was left behind in terms of oil was bound to the rocks and the pores and was essentially immobile at static and in situ reservoir conditions. Now, after that, according to Empire's expert, Dr. Lindsay, some of the oil that had been swept migrated back into the EMSU after that hydraulic head was turned off, partially resaturating the Grayburg and the Grayburg, okay, but not the San Andres. He testified in his deposition that the San Andres never resaturated. The only oil left in the San Andres was immobile oil that had been swept and at very low concentrations or saturations. That is what residual oil is. Oil that was left behind in the residual oil zone. Now, according to Empire's experts, what you see after the Mother Nature's water flood are oil saturations that are very similar to what you see after a man-made water flood. Now, Goodnight's experts mostly agree with this story, except for one big thing. They don't think that the evidence supports the conclusion that the San Andres was ever saturated with oil. They think the evidence instead supports concluding that the San Andres was more likely a migratory pathway for oil, moving through the San Andres up dip from source rock in the Delaware Basin. And why do they think that? Because the residual oil saturations are too low in the San Andres to have been saturated with oil. And the sparse, intermittent oil accumulations that they see in their log interpretations are not mappable across the area. That means that the San Andres at the EMSU does not match the definition of an ROZ in the literature or in practice. It doesn't have the oil saturations necessary for a commercial development because it was never saturated. It was only ever a migratory pathway, and it was never resaturated at the end of Mother Nature's water flood, unlike the overlying Grayburg. Now, what does that mean for the EMSU? It means that we would expect to see good residual oil saturations at or above 20% down to the base of the Grayburg, because the Grayburg was at one time saturated before Mother Nature's water flood, and it resaturated. But below the Grayburg into the San Andres, we would expect to see oil saturations below 20% because it was never saturated. It was only ever a migratory pathway for oil and was never resaturated after Mother Nature's water flood. And that's just what we see, okay? This is a slide, again, from Goodnight's exhibits. It shows all the core data that we have for the EMSU. And again, it shows that Goodnight has picked minus 652 sub C as the last point where there are consecutive core oil saturations above 20%. Below that, oil saturations drop off. That makes the base of the Grayburg RZ at about minus 652 sub C, above where Goodnight's disposal zone starts, here at about minus 700 feet sub C, where the core oil saturations are all below 7%. Empire's expert, Dr. Trentham, testified in his deposition that he could not disagree with that depth as the base of the ROZ, but he might put it a few feet deeper. That would make the ROZ and the MSU a little more than 300 feet thick. Based on what we know about the ROZ oil saturations decreasing with depth, there's no basis to believe that there will be any higher oil saturations deeper in the San Andres than what has already been revealed in more shallow zones, especially not below what is depicted here to be the paleo water contact. How does his testimony support all this? This is a table from Dr. Trentham's testimony. Dr. Trentham says that the EMSU, in his estimation, based on what he understands from Dr. Lindsay, it all depends on where you put the oil water contact or the producing oil water contact. Trentham says that the EMSU has a 370-foot thick ROZ. That's almost already thicker than any ROZ interval that has been developed. Okay, you can see them all here. XDO, in its brochures, in an effort to sell the property, told Empire in its documents that they think there's a potential for a 300-foot thick ROZ, down to as deep as minus 700. In contrast, Empire, in its petrophysic analysis, is essentially saying that there's a commercial ROZ in the Grayburg and the San Andres that is at least 1,200 feet thick or more with substantial oil saturations all the way to the base of the San Andres. That would be at least 3 times thicker than any known commercial or pilot ROZ anywhere in the Permian Basin. That's extremely unlikely. Not only is it unlikely that the core oil saturations that average 7% at that depth for 100 feet are suddenly going to increase to over 20% based on what we know about ROZs, but it's also unlikely for at least the following reasons, just based on Empire's own experts. Dr. Lindsay testified in his deposition that the only confirmed ROZ that he knew of in the MSU is limited to the Grayburg, and it follows the base of the Grayburg structure because there's a composite sequence boundary that he says serves as a barrier to flow. Here's a slide from Dr. Lindsay's testimony, and he's identifying right here the ROZ terminates at this base of the Grayburg because of this composite sequence boundary. And he says it's mostly on the western half of the EMSU. Asked whether he was aware of any ROZ that spans a composite sequence boundary like the one between the San Andres and the Grayburg, he testified no, it would be unique. He also testified in his deposition that there was only a potential ROZ in the upper San Andres and that it is speculation that there's an ROZ in the lower San Andres. What if we step back and look at this from a wider angle? Does the broader production history align with this interpretation that I'm proposing to you? That the San Andres in and around the EMSU was never a saturated oil reservoir and therefore would not be a potential ROZ? Yes. Our expert, Mr. Bill Knights, reviewed the production history in and around the margin of the Central Basin Platform where the EMSU is located. Unlike the fields around it, more than 7 miles away, the EMSU does not have a productive San Andres interval. To the south and to the north, there are fields with production in both the Grayburg and San Andres. Okay. When I enter the east across the top of the Central Basin Platform and the northern shelf, there are fields that also produce from deeper zones down into the San Andres. This all has to do with the fact that each of these productive San Andres fields have unique characteristics for production that don't apply to the EMSU, and it all has to do with the oil migratory pathways. Does the same pattern show up in ROZ plays? In fact, there are no ROZs on the west side of the Central Basin Platform and south of the San Simon Channel, let alone any that target the San Andres. Why is that? Well, there's a reason for it. And it's not because the San Andres or ROZ have been overlooked at the EMSU. It's because it does not have the oil saturations necessary. At the beginning of this opening, I promised that I would, that despite all the technical testimony and all the technical issues and concept, logic and reason would ultimately carry the day. I'll leave you with 3 simple things to keep in mind as you review the exhibits and listen to the testimony. First, remember to ask yourself, is the testimony that you're reviewing or hearing on the San Andres specific to Goodnight's disposal zone, or is it something shallower? Second, Goodnight has encountered a very real and substantial pressure differential below its perm barrier at the same stratigraphic level across all of its wells inside and outside the unit. That is a very real, tangible demonstration that there is an extensive and effective perm barrier between the disposal zone and everything above. Third, there's no need to conduct any more tests, collect any more data, or conduct any pilot projects on the disposal zone. It has been subjected to a definitive ROZ test through a massive depressurization over more than 3 decades. 380 million barrels of water has been withdrawn from that same zone, and not a single barrel of oil or skim oil has been produced or reported. If there was a residual oil zone down there at the saturations that Empire's experts are claiming, some of that oil would have been mobilized and produced. It's not the case. A testimony will show that Goodnight has painstakingly evaluated the San Andres in this area. It's an ideal location for produced water disposal. It's expansive and it's got lots of capacity, making it a critical resource for managing disposed produced water from horizontal well development in the Delaware Basin. It's underpressured and has significant capacity because it has been depleted after decades of massive water withdrawals from across the area, not just in the EMSU. There's 16, 17, 18 additional water supply wells that have withdrawn massive barrels out of the EMSU. Goodnight has calculated anywhere between 850 million to 1 billion barrels of water have been withdrawn out of the San Andres in this area. It has substantial and effective geologic seals, which prevent communication between the injection zone and the overlying production Grayberg formation as well. In short, the overwhelming, not in short anymore, weight of the evidence will show that the proposed injection will not interfere and has not interfered with unit operations, will not cause waste, and will be protective of correlative rights and otherwise comply with the Oil and Gas Act. Now, I want to make one additional statement. Each of Goodnight's experts have conducted an independent analysis. They've been unbounded by my direction or Goodnight's direction. We did not direct them to an answer. Their direction from me and Goodnight was, what is the answer here? Is there an ROZ? Can it be recovered? Is it economic? Is the disposal water communicating with any of the formations above? Is the EMSU water flood operations, are they being impacted? Is there any evidence of a geochemical fingerprint reflecting Goodnight's disposal in EMSU operations? We told them what we think, but we wanted them to test our analysis. We asked them, tell us, are we wrong? Why are we wrong? Or tell us we're right. I cannot wait to get them in this room. Okay, I cannot wait to get them in this room, and I want you to ask them all your questions. Okay. With that, Mr. Chair and Commissioners, after you hear all the evidence, we ask that you approve Goodnight's applications and that you deny Empire's efforts to revoke their existing saltwater disposal wells. Thank you.
Okay. Thank you, Mr. Rankin. Mr. Molander, do you have any idea how long your opening will be?
I'm anticipating 15 minutes, probably at the maximum. It'll be abbreviated relative to other openings today.
Okay. Well, if it's that short, I guess my suggestion is that we simply proceed, and that'll bring us conveniently to the lunch hour. If it's longer than that, then we may cut you off and bring you back.
I will happily accept a break if that's required, but I'm pretty confident I can get through what I need to.
Is that okay with everybody then, that we just proceed with the, all right.
Yeah, I think it's good.
All right, OCD, Mr. Molander, you're on.
Thank you, Mr. Hearing Officer, Commissioners, Mr. Chair. Now for something completely different than what you've heard this morning. OCD comes before the commission with an information problem. Some of the commissioners may be familiar with this. It comes from economics. It's the idea that when information is imbalanced in a dynamic, usually more than two parties, that somebody in that dynamic is probably going to lose unfairly or will be shorted. OCD looks at this issue as essentially the problem is as follows. OCD doesn't know what it doesn't know about potential impacts from San Andres injection in the EMSU to the Capitan Reef via what we suspect is the Hobbs Channel. So OCD actually agrees with Empire that we don't have evidence proving something one way or the other. That's why we're here, because we want to find out. OCD's hypothesis is simply that it suspects there's an underground hydrogeologic event occurring that ties together the EMSU, the Hobbs Channel, and the Capitan Reef. OCD does not know what that event is, but it fears that injection of produced water from oil and gas operations is a contributing factor to the increased water volume in the Capitan Reef, potentially leading to reef contamination, violation of the Safe Drinking Water Act, and ultimately a possible exemption of the Capitan Reef aquifer. OCD's proposed solution to resolve both the problem and its hypothesis is to obtain OCC authorization, implement an investigation and monitoring program to assess and characterize the relationship between the San Andres Formation and the EMSU and the Capitan Reef. Probably not surprising, OCD lacks the resources and labor pool to effectively conduct this project on its own. This is a heady task before the OCD, and it's going to require assistance of industry to accomplish this. OCD's evidence is laid out in 4 or 5 different groupings. OCD will start with what we're calling the lay of the land. We're going to provide it, and you'll notice I'm not putting up all these maps because you've seen plenty of that today. So this is going there. You will see these. I believe you've already got them. A current overview of all wells and all UIC Class 2 permitted wells in the EMSU. We'll narrow down a bit further to both Goodnight and Empire wells that are currently in this water flood. OCD is also going to provide Department of Interior and New Mexico Tech reports on disposal operations in the Permian. As both parties have provided today, the barrels, and just as a reminder, these are 42-gallon barrels, the volume of barrels injected in the MSU is a lot. It is a humongous number. I would say when you start doing the math on 42 times any given number of proposed assessments of water injected, it starts to get astronomical in size. This particular document between Department of Interior and Tech also confirms that the San Andres has largely been deemed a preferable location for produced water disposal. The second category of evidence that will be presented to the OCC involves Section 70-2-12B of the New Mexico statutes, which outlines OCD powers, authority, and so on. We'll walk through those and show the various sections, which have been argued at some length in motions already, that OCD has authority to pursue this investigation and monitoring project. This will also include a brief discussion about the Unitization Act. Now, why that's important is because the Unitization Act has as part of its foundation, or at least contributing factor, is what's called the UIC program. It's the underground injection control. This program has its roots in EPA regulations tied to the Safe Drinking Water Act. The hallmark exhibit of the law here that governs what OCD is attempting to accomplish is what's called the Appendix 2. And what that document does is it grants OCD primacy status to enforce the Safe Drinking Water Act in New Mexico, but it also obligates, and that we should look at that as an obligation. That's a requirement. Specifically relevant to the Aquifer Evaluation Program that falls underneath both the UIC program at the state level and the Safe Drinking Water Act at the federal, OCD is tasked with studying, classifying, delineating, and then protecting potential potable water sources. This particular program, as well as the EPA regulations, are applicable to the San Andres Formation and the EMSU. Turning to the expertise documents, you're going to hear almost all of this testimony from OCD witness Philip Getz, who is the UIC program manager and has extensive experience in not only managing the program, but produced water issues generally when it comes to injection. The first you'll see there's a series of these expert papers. Several of them are written by the same author, and there's a theme running here. The first article that we'll have a talk about will be one written by a fellow named Hiss. He has mapped out, and most of this work was done in the 70s. It is that we acknowledge openly and without question, this is aged data. Unfortunately, OCD believes it's the best data available that's in terms of a summary or a collection that one could look at to get a sense of what's gone on with underground injection down in the MSU. The first Hiss article has maps on it that are going to show where Hiss suspects, based on his chloride ion testing, there is a Hobbs channel or a form of an underground water pathway that flows near or around the MSU. And it generally shows the relationship between the Hobbs channel and the Capitan Reef. The next HIS article that OCD will walk you through is what I have labeled the notorious HIS paper from 1975. It has caused quite a bit of an uproar. It's at this point arguably controversial, but it's the keystone document upon which OCD built its current UIC program. It was also influential in the Appendix 2 that granted from the EPA to New Mexico the primacy to regulate underground injection and protect water, potable water. This article also sets OCD's standards for addressing disposal, as well as its views on the existence of the Hobbs channel. Through all of the presentation of the HIS paper, there's going to be multiple maps. They're going to be demonstrating where this flow goes, and that's in relation not just about the Hobbs Channel or the Capitan Reef. It's also going to address where some of these wells at issue in this case are located. The next article is the Rassenfoss article, which came out of an industry journal. It states that water production in the New Mexico portion of the Permian Basin is increasing during oil recovery processes. For example, the Delaware Basin experienced water cuts of 80 to 90% during production operations. Next, we'll shift to articles by Mr. Lewis Land, who interestingly posits that the reef is already too brackish for human consumption. There's also an additional article to that from 1984 that proposes the reef, because of brackishness, should be an exempt aquifer based on the HIS documents. Now, I'm going to point out something here. One of the things that you will witness and that OCD will present is there is a significant amount of conflicting authority at this point. And I use authority from the legal sense, but I'll say more in a scientific sense, it's influential or informative. There's also another article by Land that maintains the reef is isolated from the Hobbs Channel, but also notes again that there are rising water levels being shown out of production. The last, I'll call them expert articles, is from the Texas Water Development Board. I believe the commission is likely aware that Texas has a very different view on how it regulates oil and gas production. So again, we're going to have a contrasting, differing, distinct view. This document shows that the rising water level issue in the Permian Basin does exist, but acknowledges there may be a hydraulic connection between the reef and the San Andres. Once this is we've gone through all this, and Mr. Getz has provided his input on it, which is, it appears like there's something going on, but we don't really know what it is. And the solution again to that is to get an investigation and monitoring program into place. OCD will walk you through OCD's analysis of the matter through the lens of some of the cases that now form the main case before you. Some of these will involve documents going back as 1954, reports that were submitted to OCD per its regulations and requirements, and will extend all the way through 2022. As noted, these are early filings at a time where the unit didn't exist, but there had been some pooling that had gone on. But it'll work up all the way past the unitization up to effectively to date. OCD is also going to provide a selection of its communications with various state and federal regulations concerning protection from the Capitan Reef. These documents address historical water level changes in the reef. It also reflects OCD's investments and injection impact on the reef, which has, in OCD's view, largely validated OCD's concerns as they've arisen through this case. Talking about what will happen with a program, OCD can't speculate and won't speculate as to what it's going to learn. That's the whole purpose of having the program implemented. But what OCD can speak to is going to be the consequences, potentially, of a lack of a program. OCD will present a chronology of what happens to a state, in this case, the state of California, that fails to protect drinking water by allowing oil and gas operators to tap into a protected aquifer in violation of the Safe Drinking Water Act. Spoiler alert, it goes very badly for California. Further consequences, though, more specific to New Mexico, if OCD does not obtain direction and implement its program. And again, you'll hear this from Mr. Getz. First will be exemption of the Capitan Reef Aquifer. Now, that has a special meeting under the Safe Drinking Water Act, which will walk you through that. That means that the aquifer may be used for oil and gas operations, which is not currently the case. On the other corollary of that is there's a loss of potentially potable drinking water source in southeast New Mexico. On top of all that, violations of the Safe Drinking Water Act include a whole panoply of potential consequences, but a primary concern to OCD is it would result in the OCD Underground Injection Control Group being directly supervised by the EPA out of Washington, D.C. OCD would lose all local control of the program. This also would come along with increased and onerous reporting requirements that would already delay OCD action and paperwork. And then finally, the reputational black eye for New Mexico, that New Mexico managed to end up with an exempted aquifer that theoretically at this point could have been drinking water in a rather arid and water devoid location in the state. Turning to the opposing evidence, the opinions from Empire and Goodnight at this point are just another opinion on top of another opinion on top of another opinion on top of another opinion. The solution to that is to resolve all doubt and to allow OCD to pursue its investigation and monitoring program. There is, just through the documents I've walked through today, there is no consensus or generally accepted understanding of the overall situation involving the Capitan Reef in relation to the Hobbs Channel, the San Andres, and the Permian Basin. OCD's proposed project should provide insight and clarification on that and hopefully drive towards a generally accepted understanding. OCD is well positioned to take up the responsibility of working towards that consensus or generally accepted understanding through its proposed plan. So what is the proposed plan? On a surface level, OCD wants to institute this program to determine the hydrologic relationship between the Capitan Reef and the Hobbs Channel, determine any impacts to water quality if commingling does exist between disposal fluids injected in the San Andres and the Capitan Reef, and then finally characterize the Capitan Reef in this area to determine the current status as protectable, with the intent of either establishing a monitoring plan for continued management, which would be continued protection, or as a underground source of drinking water, or considering the possibility for aquifer exemption for the portion of the Capitan Reef from the Hobbs Channel to the New Mexico state line. During the hearing, Mr. Getz will go into the minutia and the detail on this plan as to exactly what OCD seeks to require of operators. OCD is aware that these sorts of plans are certainly not popular, but in this instance, the loss of UIC primacy would probably border on the catastrophic and would reduce OCD's ability to continue protecting underground sources of drinking water locally. OCD looks forward to seeing everybody next week and is eager to put Mr. Getz on the stand to help provide more support for OCD's proposed investigation and monitoring plan. Thank you for your time today, Commissioners and Hearing Officer.
Thank you, Mr. Moander. I assume that you have Empire's agreement to your proposed monitoring program and they agree to split the cost of it?
No, Mr. Hearing Officer, unfortunately, that is not in the cards in this case. But I appreciate your optimism that settlement negotiation is ever ripe and evergreen.
All right. Well, that's hope does spring eternal even in these proceedings. All right. I'm thinking we don't need this afternoon then. And is there anything, any other item of business or anything else?
I think Mr. Rankin
I think that we and Pilot have brief opening statements to
Okay,
provide.
so what's the commission's preference? Would you like to hear those now or adjourn and come back after lunch? We have a luxury of the entire afternoon if we want it.
Mr. Beck and Mr. Saza, how long do you think yours are going to take?
Mine will take 5 to 10 minutes at most.
Okay, Mr. Beck.
Same.
I say we kind of plow through this and we then are done. Does that sound okay with the commissioners? Mr. Hearing Officer, is that okay with you?
I defer to the commission on all matters of any importance whatsoever. So you guys want to flip a coin or you know who's going first?
I defer to my friend, Mr. Suazo.
I'm glad to start. All right. Good morning, commissioners, Mr. Chair, Mr. Hearing Examiner. Miguel Suazo on behalf of Pilot Water Solutions with the law firm Beatty & Wozniak. Pilot appreciates the opportunity to be in part of this case on behalf of Pilot, and largely Pilot's in support of Goodnight's position. Pilot feels that this case presents a fundamental issue of regulatory integrity, geologic reality, and the fair administration of longstanding orders governing the Eunice Monument South EMSU. Now, Pilot has a small interest in the EMSU and operates only a small marginal well, as Mr. Rankin mentioned, the P15. But Pilot has significant operations in the surrounding area that would be impacted by a decision in favor of Empire in this case. Now, Pilot's team has reviewed the evidence in this case and adamantly opposes the claims that injection into the San Andres migrates to the Hobbs Channel and then migrates to the Capitan Reef. Pilot believes that the facts and science are clear and that there's a lot of fundamental flaws in Empire's analysis and that the San Andres Formation should be moved from that scope. The San Andres is not and has never been a commercially viable hydrocarbon reservoir within the EMSU. For more than 60 years, it has been designated by OCD as a water management zone, a formation for produced water disposal and reliable water supply for secondary recovery operations. The inclusion of the San Andres in the EMSU's unitized interval was, we believe, and agree with Goodnight, a historical error and one that must be corrected to reflect the true geologic and regulatory framework. Now, there are lots of implications for a decision in favor of Empire in this case. As Mr. Rankin mentioned, there's over 60 SWDs just in the vicinity, and there's a lot of operators that would be affected, as with the entire oil and gas industry. Pilot believes that the San Andres is geologically distinct from the Capitan Reef complex. And Goodnight's stratigraphic analysis confirms that the San Andres Formation is not stratigraphically or temporally equivalent to the Capitan Reef. The Capitan Reef is laterally separated from the San Andres by more than 2 miles, eliminating any possibility of contamination. And OCD has repeatedly approved Goodnight's disposal wells in the San Andres under this understanding, most recently in March of 2023. Again, Pilot takes a position that this is not an oil-bearing reservoir in this region. So Empire's claims of waste and correlative rights violations are essentially baseless. The Capitan Reef does not play a significant role in domestic water supplies in Lee County, as the primary municipal water source is the Ogallala Aquifer. The Capitan Reef is highly saline, with a total TDS of over 10,000 milligrams per liter. Pilot believes that Empire's claims are based on misinterpretation and speculation. They claim that the San Andres contains a residual oil zone of commercially recoverable hydrocarbons. Pilot does not believe that's the case. They also claim that Goodnight's injection wells are watering out the Grayburg production and impairing secondary recovery. Empire's ROZ argument is unsupported by the reliable data and contradicts historical production records, as Mr. Rankin mentioned in his opening and as his evidence will show in this case. Now, it's important that operators in this area have regulatory stability, and that's where the role of the commission comes in. Beyond the geological and technical facts, this case carries significant regulatory implications, and OCD is rightly concerned that amending decades-old orders could destabilize established regulatory frameworks. And Pilot's sensitive to OCD's assertion about the UIC program. However, we think that the facts and evidence in this case, does not warrant those concerns. So in conclusion, the evidence overwhelmingly, we believe, supports Goodnight's position. And we respectfully request that the commission recognize the fundamental flaws in Empire's claims and reject its efforts to rewrite the history of this area and grant the relief sought by Goodnight. Thank you.
Thank you, Mr. Suazo. I didn't mean to overlook you or Rice operating, so appreciate that. And
No problem.
Mr. Beck, I'll turn it over to you for Rice operating.
Mr. Chair, Commissioners, Hearing Officer. Rice Operating Company and Permian Line Service LLC want to state their position. They want to underscore the OCD's concern for institutional stability. All of that supports denying Empire's applications to revoke Goodnight's valid injection permits in these hearings. You heard a little bit about Rice and Permian from Mr. Rankin. Rice began operating in New Mexico in the 1950s. It currently operates 3 saltwater disposal systems, including the Eunice Monument Umont EME saltwater disposal system. The EME Articles of Agreement were executed in June 1958, almost 67 years ago. Gulf Oil Corporation, Empire's predecessor in interest, was an original party to the Articles of Agreement for the EME SWD system. In addition, over the last 60 years, Rice has operated as many as 9 saltwater disposal systems in and around that area. Permian Line Service was established in 2013. Its predecessor in interest began in the early 1980s as a line servicer and roustabout company, primarily for Rice. In addition, Permian Line Service operates the N11 well in the IMSU and the L21. All of Rice's and Permian Line Service's wells inject into the San Andres, or what you heard referred to as the Goodnight disposal zone. They all inject on vacuum only. Rice's operated wells include wells dating back to the 1950s, including in the EME system and the EMSU, as you heard. This hearing raises concerns not only for the Commission, not only for the OCD, not only for Empire and Goodnight, not only for the interveners, Rice, Permian, and Pilot. As the division points out in its direct testimony from Deputy Director Powell, quote, "This action does, however, have the potential to have not only regional effects, but also more profound, far-reaching consequences." He goes on to point out that the OCD would specifically point out through the respective applications, one of the remedies sought is adverse actions regarding previously issued OCD orders pertinent to the operator's injection authority. Deputy Director Powell wishes to convey the importance of only doing so with an abundance of caution and offers the following in support. That when operators apply for OCD permits to inject, they do so through rules promulgated by the OCC. It should be recognized that the rules promulgated by the OCC allow an offset operator with concerns the opportunity to contest a permit prior to issuance. Empire's predecessors in interest never did that, and as I mentioned, Gulf Oil Corporation was part of the EME system, the same EME system in which Empire remains a party today. A result of such permit approval leads operators to invest money, time, equipment costs, and other expenses in both preparing to apply for the permit, but also afterwards in the actual process of implementing the permit by preparing a well site, drilling a well, and then subsequent injection. In essence, operators rely on the injection permit as the bedrock for the operator's investment in a given well or wells. The oil and gas industry is built on nearly a century of regulations and statutes executed through permits and orders that were validly issued to Goodnight, which Empire now seeks to revoke. Direct testimony of Deputy Director Powell goes on to say it is in the interest of OCD and therefore New Mexicans and the regulated community for OCC to build and maintain a stable and reliable regulatory structure that yields industry compliance with OCD regulations and statutes. Such consistency reduces uncertainty for operators working in a dynamic industry. A dependable regulatory regime likewise allows for operators to act efficiently, which in turn generates tax revenues for the state. Therefore, the risks of adversely affecting existing orders are significant and should only be done with cautions and only if there is an abundance of evidence. OCD's position in this case is that the burden lies with the operator moving for that adverse modification to demonstrate to the Commission the level of information to meet such a threshold to justify an order of modification. That threshold to justify the order of modification is an abundance of evidence. This represents an existential threat to the regulated industry's efficient operations. Empire has not and cannot meet that significant threshold of an abundance of evidence to warrant revocation of validly issued permits. Permits which it had the ability and the opportunity itself and through its predecessor and interest to object to. But as you heard from Mr. Rankin, it did not. As you heard from the OCD, all operators in this area recognize that the San Andreas is a commercially viable disposal target for permanent operations throughout the area. We all know disposal water is a necessary byproduct of oil and gas production. All parties here commercially dispose in the San Andreas. Goodnight, Rice, Permian, Pilot, and even Empire. In the OCD's pre-hearing statement, UIC Manager Philip Gates says that he reported to the EPA in 2020 that, quote, the industry is still interested in using the San Andreas as a disposal zone. There's additional support for denying Empire's applications found in the OCD's response to Goodnight's motion for partial summary judgment on the EMSU unitization orders. The OCD points out it's recognized facing with relief affecting validly issued orders, there are legal principles, including stare decisis and laches, that weigh in support of precluding such relief. In that filing, the OCD said, quote, Goodnight sought relief will result in regulatory instability and is well past ripe for consideration to the point reconsideration would cause a mix of harms. It says that in relation to a unitization order that was entered in 1984, 41 years ago. It says that overturning that would result in regulatory instability as well as entice operators to challenge long-standing unitization and other orders. The OCD points out that the doctrine of laches should preclude that parties should not be permitted to grieve about orders it and other EMSU operators could have addressed long ago. In the OCD's words, and I'm sorry, I'm not as good at Latin as Mr. Moander is, invokes the doctrine of ab assuitis non fit injuria. And luckily, right in that pleading after he says that, he says what it means in English, which I can read, which is no injury is done by things long acquiesced in. Well, Rice and Permian disagrees with the application of that to the 1984 unitization order. It applies here for Rice and Permian specifically, where Rice has had validly issued division permits to inject for over 60 years into the San Andreas, or what you heard referred to as Goodnight's disposal zone. Now, this isn't to stress a parade of horribles or talk about concerns in the abstract. Empire filed applications to revoke Rice's and Permian's injection permits, including for the over 60-year-old well that Mr. Rankin described to you earlier today. As part of these proceedings, the commission stayed those applications. It lifted that stay to dismiss all of those applications, but without prejudice. And it did so because Empire specifically reiterated in those dismissals that it wanted to have the opportunity to refile those cases and seek to invalidate Rice's and Permian's longstanding injection permits in the future. So Rice and Permian stand behind Goodnight, and they reiterate the far-reaching implications to the regulated industry and Empire's requested relief here to revoke Goodnight's validly issued injection permits. The commission should not grant that relief. To the extent that the commission decides to grant relief, it should do so with these thoughts in mind, and it should do so in a narrowly tailored manner that recognizes the necessary industry reliance on the institution of the commission and the division, including respecting validly issued division orders. Thank you.
Thank you, Mr. Beck. I believe that concludes all the scheduled presentations for today. Is that the understanding of the commission?
If I may, Mr. Hearing Examiner, members of the commission, I was considering whether or not I needed to make any initial comments, give any initial advice to the commission. Based upon what I've heard by the very capable attorneys here and by the excellent presentations, I don't really see too much in the way of red herrings. I don't want to get in the way of lunch, but there are, if I may, and of course, I have the luxury of giving you advice in closed session at the end of this as well. But if I may, I do have one point that I would like to address to council, as it would be helpful for me ultimately in advising the commission, if I may.
Don't let me constrain you on time. We've got all afternoon for lunch. Take the time you need, Mr. Rubin.
Oh, I don't want to I just have one comment, I think, at this point, perhaps two, and then we'll break for lunch. My first issue that occurred to me that might be helpful here, something from the parties on, is to the extent that there is an ROZ that's dependent upon CO2 flooding. And this goes back to my state engineer days. To the extent that there's an impairment argument to be made based upon increased costs to Empire. I am not sure what the impairment standard would be as to what would be more than a de minimis cost. What is the cost that would constitute an impairment of correlative rights? I don't know if I'm going to hear testimony on that. We certainly have case law that talks about how it's about variable costs, not fixed costs. And the case law that that goes to that point. That would be something that might be helpful for me to hear. There's been some discussion about latches and delays, and I can tell the parties here that I do have a concern about equitable issues such as latches and what has come before, and stability coming into play when this commission has a statutory obligation, which, as stated capably by the lawyers, goes to protecting correlative rights, avoiding waste, avoiding drowning, and also the standards that govern produced water injections as well. Now, of course, like a district court situation, Empire has a lawsuit against Goodnight, and the doctrine of latches in district court might be a good defense to that trespass case. But here I am concerned that this commission do anything based upon upsetting what came before if it gets in the way of honoring its statutory obligations now. So I think that's probably helpful for the parties to hear as well. But that's all I have. Thank you.
Thank you, Mr. Rubin. Then is there anything further based on Mr. Rubin's statements that the parties would like to respond to or address at this time? I guess it falls into the category of food for thought between now and Monday morning. And if there's nothing further, then Mr. Rosatos, I'll leave it to you to do the technicalities necessary to bring this meeting to a close, with the understanding that we'll all be back here Monday morning at 9 o'clock. All right.
Just like our hearing officer said, we are now dismissed until Monday morning, 9 o'clock. All opening statements were made. Evidentiary hearing will start on Monday. So we'll see you all on Monday. Thank you.
Thank you.